Item 1.
My lords, item number 16 on your lordship's board.
16.
Item 16, 1-6. On your lordship's board, your lordship has fixed it to 2 p.m. I only pray, can it be taken up on Monday, my lords? I'm preparing a sequence of events. It will make it easier for your lordship to appreciate the matter.
Next
I only
week,
pray Monday. I will
Monday.
inform the other side. I will inform. Sorry,
Next week, any day, you see, wherever it can be.
Monday, your lordship is subject, but not Tuesday. My lord, Tuesday, I'm not there, my lords.
Okay. Thursday. How many matters are posted? 6. Just put it. Mr. Mukherjee, on Thursday we'll take that.
As your lordship, please. Oblige.
Item 1.
Month is there, that will be taken up on 19.
I had informed him before mentioning.
I did not record any concession on my behalf because my officers are here in spite of the strike, so I cannot consent to that.
Whether they doubt you.
No, but I cannot.
You are arguing so vociferously.
No, Lord, I cannot have a concession recorded. That's my problem.
No, we don't say.
Yes.
Call next week at the request of the senior advocate, Mr. Mukherjee, appearing for petition.
Oblige.
Thursday.
Well, can it be that the same 2 p.m. if your lordship is
Let
not?
us see. We don't know.
Oblige.
Item 1. Yeah. Item 1. Yes, dismissed. We have discussed the law relating to PIL. We have discussed about the delay. Yes. Item 2. Writ appeals allowed at the cost of ₹50,000. Cost to be remitted within 8 weeks to the appellant. And there is a direction to dispose of the execution within 6 months in view of judgment of the appeals court in Priam also. I agree. Yes. Item 3.
I'm not sure.
Yes.
Amount in question has already been deposited.
You have deposited.
Deposited in shape of demand draft before the bank. And I have had
Be louder.
Lord, I can also file one application that the amount in the question which has deposited in the bank 89 lakhs and 89 lakhs. Support that amount may be kept in a enrolled in interest bearing account. I have filed an application because the SA 55/25 and OA number 132/22 is pending before the London DRT court. And so in the meanwhile also below one between the bank the loan mortgage is also arranged a buyer. He has also filed an application, and my lord has also disposed of this petition before the DRT, which are pending before the
Direction to dispose of.
yes, dispose of within 8 weeks. Lordship has also given a direction to dispose of the IS within 8 weeks.
Similar order to be made now.
My lord, my respectful, because the amount in question we kept in the interest loan in account, and this cases may kindly
Why kept in loanees account? It should be adjusted to loan payable, na?
We may be permitted to that.
My lord, my respectful submission before the lordship, because the liability, I have challenged the the liability part that has not been crystallized in essay and OH pending. In that respect, I have my submission to keep that amount. And my Honorable Supreme Court has also stated, my lord, the deposit obtaining the demand draft that amount in question may be kept in a fixed deposit interest bearing account. This is the
Fact and circumstance of the case may be different, but here my lord,
You mean to say you are not liable to pay?
no, liability in which manner they have stated
Yeah.
that is challenged before the DRT in essay number essay and OA.
This adjustment will be
Subject to the outcome of
subject to outcome of essay.
essay and OA.
but this amount also 50%. He cannot, even if he challenges, it
That's what
cannot
it
go
can be
beyond.
less than 50%.
This is the 50% amount.
No, we don't agree with
I will not, your lordship, in that manner, your lordship dispose of that subject to other.
Petitioner being the borrower.
My lord, borrower and mortgage, my lord.
That's one.
No,
Being the borrower is not
My lord,
the
with
dose of
permission, excuse me.
for assailing the coercive proceedings of recovery in terms of Section 14 of the Secretariat, the Surface Act 2002. First off, at the next paragraph, at the preliminary stage of hearing, at the stage of preliminary hearing, this court had passed an order on 15/1/2026, which reads as under. Next paragraph. Learned counsel appearing for the petitioner submits, and the learned panel counsel appearing for the respondent lender bank does not dispute that petitioner has deposited a sum of 50% of the amount due in terms of the above order.
due in respect of the demand notice, sorry, man. Due in respect of the demand notice.
Towards the amount, towards the demand
notice.
raised in the notice. First one. Counsel for the petitioner submits that the petition may be disposed of with a direction to the DRT Cuttack to herein dispose of his essay number
Essay number 55/25
55 or 2025
and OA number 132/2022.
and OA number, bank's OA number,
My lord,
bank's OA number
132/2022.
132 of
2022.
2022.
2022 at the earliest. First off. He also tells that whatever amount has been now deposited with the bank in terms of order made by this court shall be subject to, be made subject to outcome of the said proceedings. First off, with this proposal, the panel counsel appearing for the respondent bank is fairly agreeable. First off, in the above circumstances, this petition is disposed of, requesting the DRT to take up the subject cases at the earliest, after giving an take up the subject cases for hearing at the earliest, after giving an opportunity of participation to all the stakeholders. First of all conditions are kept open.
Bank may be directed to appropriate the amount in the loan account.
It is open to the respondent bank to appropriate the amount in deposit subject to outcome of the said proceedings. You put this when you put above. Then that was a question. Right. Next. Item 4. Yes, sir.
Till then not to take any questions.
That stay application is pending before the DRT.
It hardly needs to be stated that because he has already 50. Still you want to follow?
No.
It hardly needs to be stated that during the pendency of the said cases, no coercive action shall be taken against the petitioner. Okay. If you come bona fide, tell us that there is difficulty and we will try to do something. Yes. Item 4. Yes,
Impugned
Mr. Ratho.
impugned order is at page 23 and Annexure 1 to the Lordship kindly turn.
23.
Right. This one page order, Lordship will allow me to read it, man.
Yeah.
This is to inform you that on the issue of grievance raised by an operating trade union regarding participation of Odisha Colliery Mazdoor Sangh in statutory, non-statutory, bipartite and tripartite committees of MCL, owing to disposal of High Court case, matter was referred to Coal India Limited for their advice and appropriate action. In reply, Executive Director HR CIL via its email communication dated 16/10/25 has confirmed that there is no legal compulsion for inclusion of INTUC in bipartite or tripartite meetings of MCL. Therefore, order of consultant of Ministry of Coal dated 11/1/17 stands. Further, General Secretary OCMS has given an opportunity by so-called dated 14/11/25 to represent his case as to why OCMS would not be disallowed from participation in any statutory, non-statutory, bipartite, tripartite committees of MCL. General Secretary OCMS by his letter dated 21/11/25 addressed to General Manager has submitted his reply. The above letters along with other relevant documents are referred to the Advocate General Government of Odisha for opinion, and Advocate General by his opinion dated 19/1/26 copy enclosed has stated that, quote, my firm opinion is that there is no compulsion for inclusion of OCMS in bipartite, tripartite meetings of MCL. Therefore, OCMS union operating in MCL can be disallowed for participation in statutory, non-statutory, bipartite, tripartite committee meetings in MCL. In view of the above, it is conveyed that henceforth OCMS would be disallowed from participation in statutory, non-statutory, bipartite and tripartite committees in all areas of MCL. This is for your information, and further needful action will be issued with the approval of the committee.
Take notice. Let us see what they will say, because there is opinion of the Advocate General.
Only one solution. That 11/1/17, that has been superseded by same department. That your Lordship will find
What is superseded?
page 203.
What is superseded?
Means subsequently the very same department superseding that 11/1/17, which has formed basis of this impugned order, has clarified that they should be allowed to participate. That has not been taken into consideration.
Therefore, take emergent notice, returnable within 2 weeks. Issue emergent notice.
My lords, I am also appearing in the same matter, lordship.
Yes, Mr. Padi appears for DST. Who appears for one? Union government.
No, it's a fresh matter.
Fresh matter. Issue emergent notice. Mr. Padi, DST Padi is requested to accept notice for.
My lord, I am appearing. Appearing for opposite partner 1 to 4.
Who? Tell
Representing Union of India.
Your good name?
SK Samantara along with Lord DSC.
SK Samantara along with DSC.
Along with DST. Along with DSJ. What is that procedure? Either you appear or DSJ appears.
My lord, I am assisting Lord DSC.
No.
I am CGC, my lord, Central Government Council. And
I was also DST, therefore do not say that. Anyone, you, if either you or that person. Government cannot pay to two persons. You know, these are not case one on the Bharati.
well, my fee may be dispensed with, but my name may be recorded and along with Lord DSC.
Now, Mr. Samantara has come to point.
Well, my fee may be dispensed with, my lord. I am not eager to take my fee. My fee may be dispensed with, but my name may be recorded.
Yes, please. Item 2 in the 3, 4. 1, 2, 3, 4. So and so. General Manager.
But I'll take out notice, Lord. 5, 6, 7, and 8.
No, 6, 7, 8.
Mr.
Chief Labor Commissioner will be represented by DSG.
DSTI, because the protocol says that.
6, 7, 8.
General Manager, Chief Labor Commissioner will be by the DST. 6, 7, 8. Mr. Merusagar appears for whom?
Well, I am also appearing for the petitioner along with Mr. Rathod.
Along with issue emergent notice to the rest, returnable within 2 weeks. Yes. About that, heard that senior advocate Mr. and Mr. Merusagar for the petitioner. So, next.
And I see little more indulgence of it. I have an interim here. In fact, similar such order was earlier stayed by the son.
There is an opinion of the Advocate General Therefore, let notice go and come. Thereafter you can
His
see.
Lordship gave a very innocuous.
What
Only I am praying for an observation that my interim prayer will be considered after the.
The application for interim prayer will be considered after the service of notice on the next date of.
So great.
Okay.
Grateful,
Item five.
Lordship.
Yeah.
Petitioner have a well loan, housing building loan in the year 2017 for amounting of rupees 4,14,417. After availing the loan, he has regularly paid the EMIs, but due to the corona, some EMIs are pending against the petitioner. That has not been paid. Now the petitioner is ready to pay the EMIs, but did not accept the authority.
Because time is over, whether for 13, 14 stage is reached now.
Yes, no.
Therefore, they said they are not accepting. But how can we alter that? Any auction, etc. is notified.
Yes, my lord.
When it is?
Annex 3, my lord.
When the auction is scheduled?
Auction was not held, my lord. Annex 3 pages, my lord.
What is that? Possession notice is already there.
Yes, my lord.
That
Annex
is-
1. Annex 1, the possession notice. Page 11.
Is when
No action has been made.
possession notice is issued.
Possession notice is issued and the Annex 3, my lord, can list.
How much money is due?
Now,
Total amount of loan is?
now he is claiming 4,73,051.
No, how much loan you had obtained?
4,14,000.
Only
See.
Yes.
14,000.
Yes, my lord. I paid
So
14, my
what is
lord.
the due?
Now the due is 4,73,051. The petitioner already paid 6 lakhs. Already paid 6 lakhs.
Issue emergent notice. Returnable within 2 weeks. Learned the EGA request, Mr. Behran request accepts notice for 2, 3, 4. First one. Next one, President Counsel for the petitioner draws our attention to the application in IN and so supported by the affidavit seeking interim protection against the coercive action of recovery. First one, he tells us that his client has already paid rupees. How much you have paid? 6 lakhs.
6 lakhs. Near about
6 lakh.
Near about 6 lakhs. Not giving the
About
statement.
rupees.
Exact statement.
6 lakh. And that during the corona pandemic, he was disabled from making maintaining the payment of regular payment of installments. So he also tells that he is ready and willing to make good the installments that have fallen due. First, he highlights the financial difficulty of his client as well. First, in the above circumstances, the application having been favored, all coercive proceedings of recovery of the subject loan are halted, subject to petitioner paying is you pay 2 lakh now.
Very high, my lord.
What way?
1 lakh.
No, you cannot bargain like that. Subject to petitioner paying a sum of 2 lakh
2 installments.
in 2 fortnightly installments. 2 equalized fortnightly installments to the family. So, filling with not only interim order stands vacated, but the petition itself runs the risk of dismissal on that ground. Yes. Item 6.
Lordship, I am a house owner and third party purchaser. Bank has taken my main property illegally, arbitrarily, very deliberately, which is not a secured asset nor mortgage deed in my absence during the pendency of debt recovery.
It is not a secured asset.
Not. I am third party purchaser. I am not borrower. That I am giving this illegal notice of the bank, Annex 5.
Can't you challenge it before the DRT?
No, there is a dispute between the seller and the bank in a DRT, but I am third party purchaser. I am having valid sale deed and a right of records in my favor.
Take emergent notice.
Yes, please.
You take emergent notice. We will issue emergent notice.
Okay. We kindly request the candidate
Issue emergency. Item 7. Generally, judges are not addressed as okay. Yes, do appear to be new. Yes, very well.
My humble submission, Lordship, would be the bone of contention of mine in the present case is, my Lord, they have issued they have classified my account as NPA, and my Lord knows that NPA is administrative work of the bank. They have to inherit to the principle of natural justice. They should have given me an opportunity of hearing to explain away as to why they classified my account as NPA. At the time, my Lord, when I have been pursuing the bank not to hold my account, and to update it.
No, there is no such ruling.
Pardon?
There is no such law. Tenon on banking, a famous book. He says there is no requirement of hearing the borrower while certifying the account as NPA. If you do not make payment, that question arises.
But I have been continuing paying.
You can't.
I have been paying. I have been depositing money. Milord. They declared my account classified as NPA when at the time, Milord, when I have been pursuing with the bank that not to not to hold my internet banking system, and also, Milord.
Next. Which is that matter? The next matter.
In that matter, I
It is item number 7.
Yes, yes.
Milord.
Item number 7.
Yes, item number 7.
I thought that you were arguing in the same matter. Yes, take that. What is the point? What is the point involved?
A point, Milord, that before classifying NPA, they
Show the ruling. Show one ruling. Any of the high courts.
Milord, one of the is State of India, Rajesh Agrawal, where it has been held that before taking, because it visits the civil consequence.
Give that copy. We'll look into dismissing the petition.
Milord, that ruling instantly I will not, Milord. But document demonstrates when I have been pursuing with the bank.
We do not want that.
Yes,
it's
I
a
understand.
matter of contract.
It's a contract.
It's a contract.
Yes.
So in contract, see, opportunity of hearing avails in the realm of public law.
I bow down.
In the realm of private law, that is contractual domain, no principles of natural justice.
But my bone of contention, Lordship, would be, but the act of classifying NPA, it is administrative. So
Administrative does not make it an action in the public law. It may be administrative between you and the bank also.
Therefore, Milord,
Are you MSME? Are you MSME?
Then perhaps if you were to be MSME,
No.
that contention is available.
If you are not MSME, what is the question?
Private borrower. Any other ground you have?
Second, Milord, immediately after issuance of 13-2 notice, Milord, NPA notice on 29-1, on 1 day interval, they issued notice under section 13-2.
Yeah. How long it should be? Which law says how long they should wait?
Look, there is no but.
I'm the lender.
But it's
I know how to protect my interest.
I may not be keeping in view the backdrop of the allegation.
Of backdrop.
But
We cannot lay down new law, new rule of banking law. We cannot lay down that.
One thing, Lord. Then, below, permit me to raise all the 13(3) capital A before the bank, raising all these points. Because, below, I will do that. Yes, I will.
Learned counsel.
Because I'm apprehending their attitude of apathetic attitude of the bank without giving.
If you give back the money, question of attitude will not arise at all. You have taken money.
I've taken.
Give it back. Over.
I have already given. What they demanded, I have deposited the amount. I have deposited the amount, but all of a sudden they said there is a hidden amount.
Learned counsel for the petitioner, having argued the matter at length and vociferously, now submits that liberty be reserved to him to work out his grievance by making an appropriate representation to the bank.
13(3) capital A.
First, in accordance with law. But do you object to that also? That the panel counsel appearing for the bank very fairly submits that if a representation is given, there will be no difficulty for taking a call on that within a reasonable time.
If my daughter's client will pay the overdue amount, that can be.
Then I will pay.
That is not there also. He is not
He adds that whatever amount is outstanding, if the petitioner being the borrower clears the same, comma, ease can be worked out.
Yes, ma'am.
First one. This is appreciated. Next one. In the above circumstances, the petition is disposed of with the above observations.
That may be given some ultimatum so that they will exercise that power, that man.
The petitioner to make a representation within
Yes.
1 week.
Yes,
And
no
the
problem.
bank to take a call thereon within 3 weeks.
Yes.
Within 3 weeks.
Till such exercise will no policy answer.
And
No,
to make it
Milord, there is-
extra କିଛି extra-
Milord, because Milord, they have
Against 13 there is no
No,
extra.
but Milord, that 13 surface has been inserted to with an instrument.
Item 8.
Milord, till such exercise only protect me. Other I'll be prejudicial.
You will say your request is rejected. That becomes worse. Therefore, we agree. Yeah.
Obligation.
Item 8.
May I please, the lordships?
Ah.
Lords, the petitioner here is the petitioner herein is the daughter-in-law of the borrower, milords.
Daughter-in-law of the borrower.
Yes, milords.
Ah.
Milords, the petitioner is herein challenging the auction notice
How? But she is not signatory to the loan document.
Yes, milords. But milords may be allowed to place, milords.
No, we are asking you.
No, she is not a signatory.
Not a signatory. There is no contract, privity of contract between the bank and the daughter-in-law.
No, milords. Initially, there was not there.
Now it is there.
Milords, now she has an interest over the auction, the property which is to be auctioned, milords, by virtue of a court residence order by the Honorable Civil.
Under the DB Act.
Under the execution proceedings, milords.
This order has been passed for residential
Yes,
accommodation under the DB Act.
Yes, milords.
But bank was not a party to that.
Bank was not a party,
Then it
milords.
will not bind the bank.
Milords, now in the meantime, milords, a maintenance proceeding was also was instituted against the husband.
Yeah.
The
Husband
husband
is the borrower.
husband is not the
Father-in-law is the borrower.
mother-in-law is the borrower who has in the meantime expired.
Yeah.
Now, milords, the husband has been deliberately not paying the maintenance amount. He has absconded. Now, milords, the wife does not have enough means to maintain herself as well. She has the only residence she has is through the residence order of the Honorable Civil Court. Milords, further, milords, for the recovery of the maintenance, the area maintenance amount, which is almost amounting to 10 lakh, milords. Another CRP proceeding was also instituted.
Now, how bank manager came for your marriage?
Milords, we have informed the bank that such
That
and
don't give a loan to this man.
no, milords. We have informed the bank.
Mortgage of the property of which year?
Milords, the property was mortgaged and the loan was taken in 2014, milords.
So when you were married,
Milords, we were married in the year 2019.
then where were you not born?
Milords, now.
Subsequent, how brother? Why
Milords,
can't you hear us? You don't want to hear us?
no, milords, my big apology.
Under the law of mortgages, Tagore lecture, there is law of mortgages by Mukherjee, famous book. Mortgage is one of the 5 modes of transfer: sale, exchange, gift, absolute transfer. Mortgage and lease are limited transfer, but it's a transfer under section 5 of the transfer of. When your father-in-law mortgaged the property, the bank interest was created in favor of the bank in 2014. You were not even in the matrimonial market at that time. You married father-in-law's son only in 2019. Section 20 of the Indian Succession Act says, marriage by itself will not create any interest in the property. That's the law. Therefore, number 1. Number 2, you did not make, you could not have made the bank also a party. The orders in matrimonial jurisdiction, they are inter-party. They bind your husband. Therefore, why public money should be left unrecovered which has nothing to do with your matrimonial dispute. The bank has, the court has ordered. What court has ordered touches the equity of redemption. It does not touch the interest created in favor of the mortgagee. After property is mortgaged, what right remains with the mortgager is called in English law equity of redemption. If mortgager pays the money, because mortgage is defined as transfer of property for securing the repayment of loan. That's the point. Therefore, what you have to do is, you can have clause on the redemption. Redemption alone is available to your husband. Whatever order the court has made, by that time there was already mortgage. So court order will not alter the mortgage, but it touches the equity of redemption. I have said which Mukherjee has said in his book.
May I be allowed to place some other facts, Milots?
Yes.
Milots, the mother-in-law, who was the original borrower, Milots, passed away in the year 2022, leaving behind the sole legal heir, that is the husband, Milots. Now, Milots, the husband is deliberately trying to evade the legal proceedings in the learned trial court, Milots. Now, the area, and only because he knows that the wife has been residing there, he has stopped only after the death of the mother paying the EMI amount. It is intentional and deliberate just to harass the petitioner, Milots. Now, if the auction takes place, Milots, petitioner will have no residence to live in, Milots.
No, it can't be. That happens.
Milots, may kindly take a look of the representation under Annexure 6, Milots, wherein the wife also tried and contacted the bank, Milots, that she is also willing to do the one-time settlement, but they outrightly rejected her claim, Milots. Saying that she...
Because you are not the borrower.
I'm not the borrower, Milots. But Milots, my rights are getting affected. I'll suffer irreparable loss, Milots.
Therefore, you should seek an order at the hands of the DV court, saying, I want to pay back the money to the bank. You permit us. You make the bank also a party, then seek that. Milots, you take notice now. Since you are saying you are ready and willing to pay, let us ask what the bank will say. Take notice.
Milots, another thing, Milots, that is to be brought in the notice of this court, Milots. In the pending proceeding of area maintenance, Milots, we have preferred an application of attachment, Milots, to recover the legal area amount which is pending, Milots. Because
attachment of what property?
Attachment of the said property.
Then that attachment is subject to mortgage.
Subject to, but that has not been heard, Milots.
You need not be heard. That's the law. You need not be held. Your all orders will touch equity of redemption. Nothing more than
Who
that.
can have charge over that property?
Milots, may kindly consider, Milots, because
you take emergent notice. Let us see. You have come with lot of preparation. We appreciate that. You take emergent notice. All right. Now it is scheduled for auction.
Auction, Milots, on
that we cannot halt. That we cannot halt. What is the value of the property?
Value of the property is valued, Milots, at page 63 at 62 lakhs, Milots.
62 lakh. Are you ready to pay 62 lakh?
Milots, I'm not ready to pay 62 lakh, but the outstanding amount we are ready to settle.
You take emergent. When the auction is scheduled now?
So on 6th of March, Milots.
6th of March. You take emergent notice, returnable within 10 days. Okay. Issue emergent notice. Your husband is not a party.
The husband is not a party to this.
He should be made a party, no?
I'll file necessary amendment.
Why amendment? I'll direct you now. The petitioner is directed to implead her husband as OP number 6. First up, petition counsel to amend the cost title immediately. First up, issue emergent notice to the newly added OP number 6. Returnable within 10 days. Post immediately after service. Item 9.
So this is a case of a disciplinary proceeding. It's on the last day of my retirement on 28th of February 2017. I was handed out the disciplinary proceeding actions. And notwithstanding my substantive other legal arguments, my main challenge is this, that there is out of 8 allegations, 4 are nothing to do with that of my conduct. And so far as the last 4 allegations, 1 was dropped, and the 3 allegations are not misconduct, and it is not proven. I challenged it, my lord, in the writ. The writ order, my lords, was not a speaking order. I approached the court, my lords, on the review, and review, my lord, only has improved upon that, but without any independent examination. Your lordship may kindly turn to page number 27 to 31 for a moment. That's my impugned judgment, my lord. That is dated 28th of March 2025. Beginning from the paragraph, my lords, 6. And this is, my lord, page number 27. May I read it from a moment?
Take emergent notice.
And my lord, my retirement benefits, despite the directions given in this, because ultimately in the review, part was allowed, part was substantive dismissal order was not touched.
Correct, but you take emergent notice. Let us see after service of notice.
No.
Issue emergent.
Well, it's now 10 years. Your lordship may at least direct in the meantime that whatever the directions given in the impugned order, it's not challenged. That portion may kindly be, that your lordship's observation will do a word of good.
Pendency of the appeal will not come in the way of giving effect to the
Paragraph number 17.
paragraph number 17 of the impugned order. If there is no legal impediment. Okay.
May kindly give a date.
No date can be given at admission stage. You want the bar to doubt the judges by fixing the date.
No, now it's 10 years. I'm retiring. I'm now 70 years of age.
Next. Item 10.
I guess interim application against the order or against the notice similar issued by the bank for the option of the
21/1/2025.
what?
Notice dated 21/1/25, 21 January.
No, that
Your prayer says that.
I am.
What has happened now? You are the borrower. You are the borrower. What is the amount of loan?
Now in the notice they have said it is 2 crores 93 lakhs million.
Yeah.
Outstanding million. But that outstanding is not. But that outstanding lot I have to repay in installments till 2031 millions because there was a restructure in the year 2021.
Loan is of which year?
Loan is of which year?
2013 millions.
2013.
2013 millions.
That's what.
But I'm just saying that.
What is the loan amount?
Loan. 1 minute. 1 minute. 1 minute.
What is the loan?
Your Lordship, kindly have a glance to my counter affidavit numbers, page 6. I have clarified everything.
We are asking what is the loan amount. We will not see anything.
Cash credit loan.
Put the number.
Cash credit loan amount is
In 2013.
You did not answer. Answering. Yes. What is the loan amount, brother? You don't prepare the small chit at all. Problem with this body.
I am just saying. I'm just
Yes,
saying.
tell.
Yes, Lord. In 2013, Lord, the bank sanctioned 2 loans, Lord. One cash credit of 1 crore 50 lakhs and another term loan 1 crore, Lord. So 2.5. Then later it was the cash credit was announced to 2.50. So total 3.50 millions. But till 2020 million, the payment was regular millions.
You have made payment till 20.
Yes, Lord. Till 20 million is regular millions.
Slowly. After making a statement, you should give full stop. So that we have to think what you are saying is right, wrong, true, untrue, false. Is it not? Whether the statement is true? Not true. He was a defaulter.
yes,
Chronic default.
chronic defaulter. This is fourth time he is filing this writ application.
What
And
is the amount?
already, your lordship, approximately 3 crores is right now balance without interest. And the OA is pending before the DRT. Yesterday that matter was listed, but they are not appearing. They are not filing their WS. Again, they are filing another IA before your lordship.
But what for?
Intentionally, they are not appearing before the DRT. Categorically, last occasion, this honorable court directed to appear before the DRT and raise all those points before the concerned court, not here. And pleadings are already complete, my lord. Counter and rejoinder already filed.
E-auction here, you are challenging.
Yes, yes.
Well,
Auction.
Yes.
Auction is yet to be held.
yet to be held on 24th, Milord. I have paid excess, Milord. That is why I have said that NPA is totally misconceived, Milord.
I raised that point before the concerned court here.
Examined by the DRT. Now,
Where is pending since 2023.
Can parallel proceedings go on the same ground?
No, when NPA, there is no NPA, Milords.
That you can take up there.
Milord, if there is no NPA on records, Milord, on records, if there is no NPA, Milords, that the proceeding under Surface Act is not without jurisdiction, Milords.
Therefore, you are before the DRT.
But they are before DRT, Milord.
Who resist their proceeding before the DRT on this ground?
Milord, when I went there, Milord, they were absent, Milords.
Yesterday you were absent.
No, because they didn't serve a copy of the...
Already served, your lordship. Already served.
Remain absent.
That is already in the record before the honorable DRT.
That is not with me, Milord. That instruction is not with me, Milord.
No.
But when I went, Milord, court directed, go there
and every
went.
time is-
Okay, please.
Okay.
Listen. When court said, go there, I went there, they were absent. They even didn't give me the application letters, copy of the application letters, for which I had to come here, Milords. For which I had to come here, Milords.
They did not give copy of the application,
Yes, Milord.
therefore you are here.
Yes, Milord.
You should complain to the DRT that they are not giving copies.
No, Milord. Before that, they are going to take possession of the...
because amount is due.
For which I had come, Milord. Milord, I had gone there. When I went there, before this...
Already, how much money you will pay now
Milord,
to stop auction?
Milord, I am not in I have paid excess, Milord. Milord, I have to give... You can hear me, Milord, so that it will be better, Milord.
What you think? This is 227 petitions.
Only 2 minutes, Milord. I will present. I had come here 2-3 times, Milord, and your lordships had directed me to pay 50 lakhs, Milord. I had paid 50 lakhs, and your lordships directed to upgrade the account. They didn't upgrade, Milords. They remained silent, Milord. I will give
50 lakhs, when you have paid 50 lakhs, which date?
Yes, Milord. Yes, Milord. It is an 50. Your lordship kindly pays.
We don't want page. We are asking on which date you made this payment.
Yes, Milord. I have paid.
Turning the pages.
It is in April 2023, Milords. And on that payment, your lordship directed to upgrade the account, Milords.
Is it true? Have they paid 50 lakhs?
Yes, upgrade the account. They have paid at 2-3.
Was there a direction to upgrade the account?
Upgrade the account, and they have to support the bank to get their GST and the income tax returns, everything. They are not cooperating us.
All right. Now we are asking you. Rightly or wrongly, there is an order for upgradation of the account.
Yes, but there is a direction. You have to go before the bank authority and submit your documents, required documents, like GST, income tax return,
GST registration,
income tax returns,
ITRs, then
stock statements. They are not submitting.
no.
It's a vital part, my lord.
All right. No, I will ask them to, we'll let them pay one more lump sum of 50 lakhs.
Yes, then I have no
Let
objection.
them, you furnish all GST, ITR, etc. Okay. We'll direct them to upgrade your account. Then you will withdraw your OA.
If they deposit, we don't have to proceed again.
Whether your
If they
client is
deposit,
here.
that's fine, your lordship.
Your client is here. No. Your bank officer, manager is here.
I have already taken instruction.
You have taken instruction.
Yes,
Bank accounts.
because your lordship.
Accounts are, I have attached note, annexed this. But your lordship will find I have paid excess the amount.
Yes, how much amount you had borrowed? How much money you have repaid total?
3.5 crores.
Plus interest at what rate? Interest.
But in the restructure procedure, I was directed to keep installments to repay the entire amount in 120 installments.
120
Each installment 3.4 lakhs.
120 installments.
That is on record itself. 2021.
Each installment is 3,40,000.
20,000.
20,000.
My lord. 25,000. The next one.
3.25.
Yes, madam. But the restructuring was in the year 2021, March 21.
So after restructure, this is the arrangement.
Yes, my lord. After restructuring.
Where are you getting?
My lord.
Where are you getting excited?
No.
Convey more, less excited.
No, not excited. I'm just
More excitement, less throw.
No,
Excitement.
not excited.
2021. Since 2021,
It is 10 years, my lord. 120 installment means 10 years, my lord. I will repay the entire installment by 2031, my lord. So now at present, my lord, I have 13 lakhs excess, my lord. I have given 13 lakh excess, my lord. I have calculated.
So how many installments you have paid so far? After the restructure?
54 of 6, my lord. 54. My lord, up to January 25, my lord. 1 minute. Up to April 25, my lord, I had paid 48 installments, my lord.
up to April.
My lord, April 25, my lord.
Is it true? What he is saying is true.
I will take instruction, your lordship.
Where is the bank?
Maleshwar.
Call next week.
But I have to submit one thing, my lord. The auction is held on 24 to 2026. This is a surface area application. How can he place right here? Because
Now,
the yet is there.
Your interest is money.
Yes.
Principal and interest.
Yes, I don't know.
If he gives that, even then you want to
If
sell
we
the
deposit
property.
the entire dues, we don't have any objection to regularize the account.
Now, see, in 2021, you have restructured the loan.
Yes,
Thereafter, you gave him 120 installments.
yes,
Each monthly installment is of the value of 3.25 lakh. Correct. He has paid 10 installments. No, 50 installments. 58 installments. That means 50% of the amount he is paid.
yes.
Please listen to us. We have to ensure that no harm occurs, loss occurs to the bank.
Yes.
That is the grand norm of bank.
Yes, madam. It's public money.
Public money.
Yes.
Our money also.
Yes, yes,
Now,
absolutely.
he has paid 48 installments.
Right.
We will ask how many installments are due now, as of now.
Well, up to April 58. Now it is 56.
56
56, another 64 minutes.
No, it is for 10, total 10 years. Na? As on this
Yes.
day, how many installments are due?
Lord, I have paid
In excess of
56. Excess of
56 installments.
50. Yes, Lord. 56 installments I have paid, Lord. And now excess of 13 lakhs I have also paid, Lord.
In addition to 50 lakhs, another 13 lakhs.
Yes,
you have
Lord.
paid.
No,
When-
56 installments, Lord. I have paid 13 lakhs more, Lord.
Against 56 installments,
My Lord.
you have paid 13 lakhs more than the
Yes, my Lord. Yes.
due amounts.
Yes, Lord.
More than, that means your original account was 3 crore 50 lakhs
My Lord.
Plus interest.
plus interest, and you have paid
More than that.
Yes, my lord. Yes, my lord.
More than the
Yes, my lord.
installments were
Yes, my lord. Yes.
you ask your manager to come
Yes,
here.
yes.
You will bear the expenditure.
Yes, yes,
Okay.
yes, yes, ma'am.
Yeah. You deposit 5,000 rupees with the court. We will ask the manager to come here
Yes, ma'am. Personally appear.
Yes, my lord. It will better.
so that it becomes easy.
Yes, absolutely.
We don't undertake accountancy strictly,
Yes, ma'am.
but we have to do the justice
But
depending upon.
absolutely correct, your lordship is correct. But
No.
I have to submit one thing, my lord. If we deposit everything, how can we proceed? How can we?
That- no, I am not sure.
Everything.
Because
No,
That is IMF.
the restructure,
No, no, that's
Brother.
what to see.
2 times restructure was made.
he also does not want to leave.
No, then your lordship.
Your interest is money. Nothing beyond that.
Then I can, then,
Is it not?
yes.
Or you are interested in causing the sale of the property. We will not permit that. Your interest is to get the loan amount back with interest.
Yes, absolutely
That's all.
correct. What your lordship saying is
Correct.
correct.
120 installments spread over 10-year period. Correct? 48 plus 8, 56 installments he has paid already. As of now, how many installments are due?
64, my lord.
64.
Yes.
So 56, another 8 you have to pay. Another 8 installments you have to pay.
To regularize it.
No, it is regular installments.
Oh, okay.
No, because I will pay 64 installments by 2031 minutes.
That is all right. Not 64 there. 120 installments.
Yes, 120 minus 56 is another 64 minutes.
No, I am not. We are not on the remainder of the installment. We are on, as on this day, how many installments it would be? Out of 120, how many installments are to be paid now?
64 minutes.
64.
Yes.
You have paid 56.
56.
So 64 is another 8. That's what our.
By this time, you should have paid 64 installments. You have paid 56 installments.
Yes, ma'am.
So 8 installment is due to be paid.
Yes.
Not
8 have
to be
fallen
allotted.
due.
As on date, your lordship.
As on date, 8 more installment was to be paid by you, which you defaulted. You have not paid EMI.
8 more EMI. You have paid 56 EMI according to you.
No, April 2025, Lord,
Yes.
I had paid 48 installments.
Oh.
48.
Uh,
So if it is calculated till date, it will be 48 plus 8.
56.
48 plus 8. It is February.
56, 54.
February.
48 by
56.
8, 56.
56 or 57.
Oh, it should be 56.
I have paid. It is up to date minutes. It is up to date minutes. I am not defaulted. I am not in the minutes.
Now, how much money you have paid? You should tell us the simple calculation. Though we are not good that good in arithmetics, but we have studied arithmetics also, maths also, as one of the subjects. We are asking you. Now, how from 2021, the first installment fell due on which date?
That itself, March, April 2021.
April. So April 21, April 22, 23, 24, 25.
Yes.
All right.
25. Yes.
Yes. From April to December, how many months are remaining?
9. Yes.
8.
Including the April, it will be 9.
If you are all right, 9.
But
Plus from December to February, how many? It will be March.
My lord, may I interfere? I am very sorry, my lord. But your lordship calculating, that is why I am submitting. Past restructure was failed, my lord. That, my lord, and that is 2/3/2021. That was failed. Again,
2/3.
Yes, my
The
lord.
first,
Past
Installment
restructure
fell
was
due on 1/3.
2/3/2021, March.
2/3 first installment.
Yeah, no, not installment. Past restructured. That was failed, your lordship.
failed in the sense, he did
They are
not
not-
pay the
He did not
installment.
pay the installment.
Yes,
So
your lordship.
from when it was to commence, the first installment was
Then
to
that was-
commence from
I am submitting.
April
Yes, my lord. I am submitting right now. Then the second restructure was made on 27/7/2022.
Already, sir. We'll go to second, 27
Yes.
to
22/7/2022.
yes. How many installments?
That, my lord, I will ask the manager.
Unless you have that. And if you want to sell the property, where the citizen should go away.
No. But the total things is, my lord, it's not cooperating, it's not submitting the electric bill,
Who will do
it's
that?
not committing the GST. How can you secure the loan, my lord?
Electric bill.
How you secure the loan, the income tax returns,
No,
the deposit,
if they
the
want
money is handling.
They
then
want,
we'll dismiss
iPhone.
the petition. We'll dismiss the, you don't appear to be fair to the court and to the bank. Take down.
I'm sorry.
The petitioner is before this court,
I'm sorry,
paying a
Lord.
challenge to the court
Sorry, Lord.
proceedings of the bank.
Lord, I am cooperating, Lord. Otherwise, how I am paying, Lord?
Original loan was of 2013. First off, it was restructured in the year 2021. First off. The second restructuring took place in February 2022.
No, my lord, no, 22/7/2022.
22/7.
Yes, my lord.
22/7.
Lord, Your Lordship, can you see the statement of accounts? Lord, I am paying, Lord.
Learned counsel of the petitioner vehemently argues that his client has made entire payment and therefore entire payment in respect of the installments that have fallen due. First, learned panel counsel appearing for the bank disputes the same. First, a writ court cannot undertake accountancy since it is a matter relating to the domain expert. First, this apart, petitioner bank's OA number. What is that OA number?
Yes, 154 of 2023.
154 of 2023 is pending on the file of DRT Cuttack, where all these contentions can be taken up with the parties. First up, already the security property is sought to be put in public auction, scheduled to be held on
24 to
24 February 2026.
Yes.
First up, that being the position, we are not inclined to interfere in the matter. Writ petition is dismissed.
Deeply obliged, your lord.
Item 11.
Yes.
May I please, the Lordship?
What else?
No, you are, you appear to be incorrigible.
Please, my point. Lord, he's paying still debt. 61.
See, you were asked to go to DRT by the other bench.
Coordinate bench had earlier also asked you to go.
No,
In another read petition, in another petition, your lordships are directed me to. They didn't, they were not present, they didn't supply me copy and went for auction, went for possession. That is why I had come to here.
We have passed the order now, right here only. Your client does not appear to be scrupulous because he says we will not produce, we will not give the.
That is that was my submission. Why your lordship said that he had said
We have,
that is,
he has engaged you, therefore we are telling you.
that was my submission.
We have noted the same. Yes, next.
Item 11.
You should suffer.
He has paid everything. After he has paid everything, now they are going to.
However, it is open to the petitioner to take up all these contentions before the DRT by making an appropriate application within 2 weeks. First off, if such an application is made, DRT to take a call thereon on a what footing.
They are going to for auction on 24th minutes.
Therefore, we have given so much time to it.
The lordship said that no
Item
course of
11.
action till the application is moved to
Next.
Item 11.
Brother, we have been heard. We have passed the order. In fact, we are not supposed to say anything in matters like this. Still, we have done some exercise.
So, I are kind enough to hear only thing is that he suffer. For me, so he should not suffer.
No, for you, he is not suffering. He is suffering for his own act of not paying the loan.
No, he is paying, Lord.
He has already paid 59.
You take up those content. We have given the liberty to take make the application before the DRT. DRT will consider it on war footing. What else we can say?
24th not
It will happen. There only
no concept. No concept. The application is hard.
You have to stop somewhere. You have to stop somewhere. It's your duty.
That is I accept. Not for that. No, only.
Next.
Item 11.
May I please, your lordship? I am for the petitioner, my lords. In this case, the petitioner has received the 14 notice for recovery of e-auction notice, whereby in the last order,
What is the amount due?
The amount due is around 14 lakhs, my lords. But in the e-auction notice, they have said the reserve amount is 36 lakhs, in which
36 lakh 58,000.
yes, my lords. I want to. I am in a dilemma. I am in a problem, my lords. I am putting it before you. The conducting council is having marriage today. Means tomorrow she has the marriage, and I am on behalf of her. But I have also power in this case. But I want to bring to the notice, my lords, the loan amount is of 18 lakhs. Two loan amount was there.
Which bank? Which bank?
Repco Home Finance Limited. The exact loan amount was initially 11 lakhs and one is 7 lakhs. He failed to pay the money.
Clear order was there from our side.
Yes,
7/1/2026. Whether that amount has been deposited, 36 lakh.
That is the dilemma, my lords. If the loan amount, it is on our part fault that the loan amount was of all total 18 lakhs. And the in the page number 22, the letter by Repco, they have said that the fixed the reserve price as 36 lakh 58,000, which was mentioned in the order. So he was not able to pay 18 lakhs. How can he pay 36 lakhs to show his bona fides?
What was the loan amount you had taken?
18 lakhs, my lord.
When it was?
The loan was taken, just minutes. In averment number 5, page number 4, it is mentioned that the loan amount is 11 lakhs and 7 lakhs for two respective loans.
So 18 lakhs.
18 lakhs in total. Whereas
Which year?
In the year?
I guess
So that statement should be with you.
yes, my lord.
There is no method of advocacy in bar at all.
And
What has happened to you to prepare a small chicken? Turning the pages, putting the finger on the tongue and turning the pages. We cannot touch it.
understood, my lord. I beg my I beg
You need
pardon.
not beg at all.
Because-
If you do your job, we won't even send you.
I received
Everybody will turn the pages. What kind of advocacy is given to you people?
I just received the file today morning only, and on a very short note, I have prepared it. I beg your pardon for this. On the next date, I will surely prepare very well. And the thing is, my lords, the amount which was said in the previous order to pay the bona fideness, to pay 36 lakhs 58,000. I request that this matter shall be referred to mediation, where both the party can negotiate and settle the issue if any possibilities are
Yes,
there.
It's already here. Notice is there.
Yes, my lord.
Then what notice? What?
This is of July 2025. Then.
Yes, my
How
lord.
can we do it at this stage?
Whether auction took place?
No.
Auction
yet.
has not taken
We
place.
have filed the additional affidavit on that regard that the auction has not taken place yet. It was failed. The auction was
When your colleague is getting married?
tomorrow only.
Tomorrow? How to pass it work all We cannot spoil her. These are her honeymoon.
So I beg your pardon, my lords. So
You pay 50% of the amount. Will halt the auction itself. All right. In 2 installments.
actually, he is not in a condition. So it may be referred to mediation.
No, will not refer.
Restructuring can be done,
No,
or
no,
any
we'll not
other
refer all those
possibilities
things.
can be done.
We can't do all that.
Understood.
It's a loan. We are not DRT. We are not super DRT. It's a hit court. Therefore, if you are ready and willing to pay 50%
I
of
seek
the amount,
instruction. I need to seek instruction for this from my client. Just one more chance may be granted. I'll seek instruction, and if
you will attend the marriage tomorrow. Call Monday.
2 weeks time will be granted.
2 weeks time. You also want to go?
Not at all. Not at all. She will come and she will conduct the case.
Call after 2 weeks at the request of the counsel appearing for the petitioner. Where is that advocate, earlier advocate? Go ahead, call him.
She
Not in this case, earlier case, na? You go and call her.
Yes, I am.
First, Behra call. All right.
grateful.
All right, all right. Convey our best wishes for the marriage of your colleague.
Grateful.
Okay. We got that order. Yeah, yes, on previous one. Post it tomorrow. Monday. Post it Monday. 2 minutes. Just say. Very better. Wednesday.
10 minutes.
10 minutes. Put it to Wednesday. Yes.
Item 12.
Well, the dishonest husband is rendered more than 20 years of service for the railway establishment.
20 years.
20 years, 11 months, 6 years.
21 years.
21 years. So, my lord.
And maybe, Lordship, in this case, I have instruction to appear on behalf of the Union of India, Lordship. And I have requested my friend to submit copy.
You are. This is for admission.
No, my lord. Hearing, because counter is filed.
You want copy?
Yes, not because previous council has.
And one more copy.
Yes.
Copy and copy.
Yes, ma'am.
You copy.
One.
We copy next. At the request of CGC.
Senior panel council, I will give the name.
So appearing for the OBs.
Great.
Item 13.
Subordinate debt. Because family pensions.
2 weeks it will come. If it does not come, we remember. Yes.
Grateful.
Item 13.
For the petition, Union of India has filed this writ application. So I have not filed rejoinder affidavit. May be permitted to file rejoinder affidavit in the course of the day. I have already served a copy to my learned senior.
All right. Rejoinder affidavit.
Take it up tomorroor or next week because
within 1 week.
I have been
next.
I have been disappointed for that daily and access of it due to the Union of India because it fortunately listed and with much difficulty they have not been listed. Hence today we kindly start.
The date now. See, when we fix the date, you shall register to post the matter. All right? Which date you want? Which date?
17.
17.
17.
17.
Sir.
17. Other. 17. What is that? 55. 54 matters? 17. Brother, 1 second. On 18.
So 11.
11. On 18 you have.
18 February.
18 February. Yes.
Item 14.
There are 2 appeals.
Yes.
For your lordship. One filed by the bank, one by the
employee.
Here in person. The employee officer.
Employee of the bank.
Employee of the bank. He was an employee, he's retired since. So your lordship, since he is in person, let him go first. I can, as your lordship directs.
Just start.
My lord, at the outset, my humble submission before lordships that the appeal advanced by the opposite party may kindly be registered.
Why 2 appeals?
My lord,
Both are agreed by the judgment of the learned single judge.
You also filed appeal and
I have filed an appeal, he has also filed.
so my pretensions are regarding molding of the judgment to a certain extent so that the bank does not harass me in further. And also, to some extent, I feel that substantial justice and complete justice need to be done. That is my prayer, At the outset, I pray before your lordships to reject that appeal of the bank because that is founded on the principles as decided by the Honorable Court that nobody is allowed to take advantage of his own wrongs to claim favorable interpretation of the law.
What are the facts? These are all principles. If you tell principles like mantra, I cannot understand. You tell the facts for.
Yes, madam, I'm going.
What are the facts?
The
What
honorable
were you in the bank?
the opposite party has contumaciously disobeyed the orders of the honorable court and has targetedly victimized.
So what
me.
were you in the bank?
When I was an officer in the bank.
Officer. What scale?
In the scale 1, OJF.
Scale 1 officer.
My lord.
What then bank did to you?
My lords, for some heavy familiar on the front of very a good deal of apprehensions regarding my family affairs, I sought reversal. But immediately after my wife recovered from illness, I applied that reference should be withdrawn. But despite several provisions in the policy, they did not consider. They reverted me, and the honorable court has awarded me continuance of this post with.
Are you subjected to disciplinary inquiry?
No, my lord.
On his own.
He sought for it. He applied for foregoing the promotion, which was accepted by the bank. After it was accepted by the bank, he wanted to withdraw it.
No, my lord, it is not like that. It is like that. There is a provision which I immediately after my wife recovered, I went to the bank and applied for withdrawing that preparation.
When you had given consent?
But I had
foregone that
7th October.
You had foregone that
1998.
Promotion
on 7/10?
1998.
1998.
But
promotion to scale 2?
Scale 1.
Scale 1.
From clerical cadre to officer cadre. Lord, in that order, my lord, I am just putting the orders of the honorable court. And the honorable court has said that certain rules and regulations of the bank has not been followed. So that is why it is a punishment. Without following the rules of the regulations of the bank, they cannot revert me. Because I had already worked as an officer. In the meantime, I have got salary for 6 months. There is no bar on me in allowing me to join the officer post. And after having worked for 6 months in the bank, they have reverted me without following the instructions. So that is the order of the honorable court that has not been implemented. Within 3 months, the order was to be implemented, but they have partially implemented the orders while promoting me. They have forgotten all those benefits that has been granted by me, and that has been already observed by the honorable single judge at page 37 of the appeal made by this bank. Well, kindly.
You are jumping over. You were working as a clerk.
Yes, my lord.
When the due for promotion came,
yes,
you did not opt for promotion.
Yes, my lord.
On the ground of
I was promoted.
You got promoted.
I have, yes.
But you did not opt for it.
No, I due to some family problems. I
gave up that promotion.
Yes, I wanted to give up that promotion.
Yes.
But subsequently, I went for the promotion. And when I represented, before they take a decision on that, I wanted to do the representation.
That you were promoted.
Yes. No, they did not promote me. They reverted me.
Reversion.
My lord, they
were already promoted.
Yes.
From clerical to
officer
scale 1.
Scale from clerical to scale 1, I was promoted.
You because of my on which date?
Promoted on August 1998, perhaps. Yes, I know.
August 1998.
But thereafter, the order was.
Let Mr. Mukherjee, you tell the fact. Let us see. First, we'll have. Then we can go to the other points. How the litigation began?
He was a clerk. He took the test for being promoted to the grade 1.
Yeah.
He qualified. was promoted, but he applied immediately on 1/9/1897. He applied to forego the promotion for whatever reasons. Now, on 7/10/1998, he applied to forego the promotion. So
having accepted promotion first,
accepted,
he said, "I don't want promotion."
I don't want promotion.
So you reverted him.
So on 11th of January 1999,
promotion was given to him when?
Promotion was given on 1/8/97.
Right. The employee was promoted from the clerical cadre to
grade 1.
Grade 1.
JMGS1.
JMGS1. With effect from
1/8/97.
1/8/1997. First time.
On 7/10/98, he applied to forego the promotion. He made a representation that he wanted to forego.
He requested for demotion to the original post on the health ground of his wife.
That we don't know. That's also not on record. He applied for that. I don't want to forego the. I want to forego the promotion. Please revert me back. This was accepted by the bank on the 11th of January 1999.
The bank accepted the request on
11th of January 1999.
Yes.
On 20th of January 1999, we again wrote to the bank
that I want to be promoted.
I want to be promoted.
On how many days he worked as in the demoted cadre?
Demoted cadre from October 98, from this about a month. Before he he was demoted on the 11th of January 99.
11th of January 1999.
And 20th.
Posted him to which place?
The original place where he was.
With effect from which date he went to the lower post? That is crucial.
Is 7/4/99 apprenticeship letter released to branch.
7/4/1999.
7/4/99.
You accepted it on 11 and reverted
in 7/04. 7th April 1999.
Was reverted on 7th April 1999.
Letter was issued him to go to the particular branch and work as a clerk.
Well, by that time, I have already worked as officer for 6 months.
Yes, that is there. That is not.
It's not disputed.
Yeah.
So on thereafter,
1 second, clarity on dates I am not getting. 7/10/98 he made the representation.
Yeah.
Correct.
Correct.
In terms of that, you took the decision on
11th of January 1999.
11/1/1999. The bank took decision to demote him on request. First time. When he applied for a recall of his request?
20th of January 99.
Oh. Before you took the decision?
After I took the decision. I took the decision on the 11th of January.
Yes. 11th of January 1999, he took the decision.
Took the decision. He applied on 20th of January.
9 days thereafter.
9 days thereafter.
Employee applied on 20 January 1999 for restoration of position. First time. And you took the decision when? He applied on 7/10/1998. Pursuant to that, you took the decision on 11th January 1999.
Correct.
Thereafter, when he sought for restoration.
Yes. That decision.
He has given
20th January 1999, he has applied. When you took the decision?
No, on 7th of April 99, we told him that you proceed on through the reverted post. So impliedly rejecting his representation.
But by that time, see, before you took the decision, he had requested for withdrawal.
No, before we took the decision on the 11th of January to accept his representation to demote him.
Demote him.
That decision was taken already.
Yeah.
On 20th of January, he gave a letter to withdraw that.
Yeah.
Now, but that was, no orders were passed thereon. But on 7th of April 99, he was asked to go and report at the demoted post.
Till then, he was not demoted at all.
Till
It was
then,
a
he
paper order.
No.
The employee was in fact demoted with effect from
7/4/99.
7/4/1999. First,
This, my lords,
he made a restoration application when?
He made a restoration application on
121 and next high segment.
On 21/99.
First representation.
That means so he was working as officer only at that time. When he was made, he was drawing the salary also.
Yes.
He was allowed to draw salary up to what point?
Up to 7/4.
Up to 7/4/99.
Up to 7/4/1999.
Yes.
When he retired.
Well, that is not the dispute now, my lords. No, that is not the dispute now. My lord, this not allowing him to be promoted or not allowing his representation to recall his earlier representation was challenged by him in a petition in 2001 before your lordships. That was, my lord, subject matter of OJC number 12217 of 2001. At page 19 is the judgment of
what the court said.
The court said that during pendency of the writ petition, the court allowed him, an interim application was filed, the court allowed him to take the examination for promotion. From grade 1 to grade 2.
Oh, from grade 1 to
grade 2, that examination he was allowed to take. Now, and it was ordered that it will be kept in a sealed cover. Now, the concluding part of the writ petition, I'm just reading out that paragraph. We therefore, for the reasons stated above, allow the writ application and set aside the order in Annexure 1 and direct the bank to permit the petitioner to continue in the promotional post from the date he was reverted to the post of head assistant. However, the petitioner having not worked in the promotional
post, be entitled to wages.
He shall not be entitled to the salary in the promotional post till he joins in the cadre of the junior JMGS 1. But the interregnum period shall be counted for other service benefits.
Yeah.
The opposite parties are directed to pass necessary orders in this regard, promoting the petitioner to the aforesaid officer grade within a period of 3 months from the date of communication of this order. This was the judgment of the, and this judgment, my lords, was delivered on the on 1/12/2011.
Yes, we'll come back within a few minutes. Back within a few minutes. So we'll hear it separately.
Here?
Yes.
That order is recalled.
That order, we had penned that order in the anger. We can't do that. Therefore, we have recalled it. We can't express our anger. I pass some order. So we have recalled that order. We'll hear it on Wednesday.
And then the law officer or bank authority may be present.
It helps actually.
Yes, my
You
lord.
keep your officer to assist you.
Yes, my lord.
All right.
I will
Do you
instruct
want
her.
any order in that connection?
Yes.
Or you will keep?
No, that is better. Your lordship may dictate. Or direct.
Learned panel counsel appearing for the bank is requested to keep one officer who knows the subject well before the court to assist in the proceedings. Call on Wednesday. Right. We have passed that order in some anger, but of course we did not intend anything else. Therefore, we have recalled it. A judge is not supposed to be angry. He has no right to be angry, even when lawyers can be. A judge is not supposed to be angry at all. He can be angry, but he cannot express that anger in his order, because we may be angry with the liar, but what the poor client will do. Therefore, we have recalled that order. Yes.
Absolutely.
Yes.
Item 14.
So they were submitting the first, during the first round of litigation, first writ petition which was pending. As an interim order, there was an order passed by the Honorable Court that he be allowed to take the examination for being promoted from grade 1 to grade 2. And that result be kept in a sealed cover. Accordingly, it was kept in a sealed cover. And as I pointed out to your lordship from the order, while disposing of the writ petition, there was no order for reopening of the sealed cover. Be that as it may, after the writ petition was disposed of, the sealed cover was opened by the bank.
And he has passed also.
No, he had failed. He had failed. Now, that being the position, Maharaj, thereafter, as he was found to be not qualified, in 2014, he filed the present writ petition, saying therein that my juniors have been promoted in the meantime, hence I be granted the promotions. And I'll read out the prayer to your lordships in the writ petition.
His juniors are given promotion in the usual course or on examination?
I'll come to that. I'll make a submission on that. The petitioner therefore prays the Honorable Court may kindly be pleased to admit the writ petition, issue rule 9 1. Why the order dated 1/4/2013 be not set aside in allowing promotion prospects to the petitioner in allowing promotion prospects to the petitioner for the interregnum period and thereafter. 2. To declare the petitioner promoted to MMGS 2, grade 2 from the year 2003-2004. 3. To consider the period from 19/3/2012 to 8/11/2014 as the completion of the mandatory assignments by the petitioner in order to make him eligible for further promotions. 4. To arrange for providing the legitimate promotional opportunities to the petitioner to the grade of SMGS 5, that's grade 5, starting from the grade 3 for the interregnum period as directed by the orders of this Honorable Court dated 1/12/2011, and which opportunity has been awarded to the batchmates of the petitioner during the meantime. Yes. 5. To exempt the petitioner from the ambit of promotion rule requiring residual service of 2 years for eligibility for further promotions. 6. Not to post the petitioner under any official junior to him as on 1/8/97 till exhaustion of all the backdated promotional avenues up to the grades as enumerated above, and any other order deemed fit may please be passed. These were the 6 prayers with which he filed the writ petition. Well, the writ petition filed in 2014 remained pending and was...
Whether any lawyer, language of the prayer appears to be of a lawyer.
Yes, my lord.
Lawyer appeared.
At that point in time, when lawyer was.
Okay.
Well, this writ petition was ultimately disposed of by the impugned judgment. Page 25.
Which of the prayers have been granted in that?
Now, I'll read out the
operative portion.
Operative portion. Considering the rival submissions of the petitioner and the opposite party, this is at page 47, paragraph 45. Considering the rival submissions of the petitioner and the opposite party bank and that of the learned amicus curiae, while being cognizant of the fact that the petitioner has not discharged the duties of the promotional post, but at the same time being alive to the plight of the petitioner being deprived from availing promotion because of the arbitrary action of the bank, in not considering him for promotion as and when due, and since his juniors in the rank of MMGS2 have been promoted, and taking cue from the judgment of the apex court in the case of Comptroller and Auditor General of India versus Jagannathan, it is quoted with approval in Hargovind Yadav, thereof, which is extracted hereunder. As the petitioner has attained the age of superannuation in the meanwhile, this court is of the considered view that directing the opposite party bank to treat the petitioner to have notionally retired in grade 5 would meet the ends of justice and shall be equitable. So he was in grade 1. He was, by this judgment of the learned single judge, he has been granted promotion to grade 5, which the bank is assailing. My lord, there are
those who were appointed along with him around that period, which scale they have attained?
Grade 5, they would have attained. But, my lords, having said that, my lord, there are two channels of promotion in the State Bank of India. One is merit. The second is seniority cum merit. Now, my lords, he claims his promotions not on the basis of merit, but on the basis of seniority cum merit. Now, for seniority cum merit, there are two things, my lords. One is, during pendency of the writ petition, there were two promotional tests which were offered to him in 2014 and 15. He refused to take those tests. Besides that, there is a condition in the service rule of the bank that for being considered on the basis of seniority, evaluation of the candidate, this is assignment, appraisal, report.
Like our CR.
Yes. So, my lords, this appraisal reports in respect of the writ petitioner were not available because he never served in grade 2, he never served in grade 3. So question of his is being considered from grade 2 to grade 3 or grade 3 to grade 4.
Which is the bank regulation?
State Bank of India.
Show the regulations. They have regulations. They have a separate act, State Bank of India Act.
Well, these are part of the record. I think they're all. In fact, this writ petition was heard once, and judgment was reserved, but unfortunately.
No, this is not, this is only circular.
Yes.
They have regulations because I used to appear for the State Bank of India.
Yes, but the regulations.
There were regulations.
May I make a submission?
There is an act and regulation.
Yes.
In addition to that, the service rule is there. So the regulation is particularly for the operational purpose, and one section is there for the promotions and service. That by virtue of regulation, this in the State Bank of India service rule has been there.
You don't have a copy of the rules.
Let me submit one thing. Whatever the rules and regulations.
The senior advocate is on his feet. We'll hear you also. We'll hear you also. Mr. Mukherjee, there are regulations.
There are regulations. Well,
regulations deal this aspect of the matter.
Yes, well, and that has been explained in the circular. Your Lordship may kindly see the circular. May I place the circular? This staff officers promotion policy for general cadre officers for promotion to MMGS 2 and MMGS 3 because he was in MMGS 1. So JMGS 1, the next is MMGS 2 and then MMGS 3. The Executive Committee of the Central Board in its meeting held on 28th of December 2007 has approved a revised promotion policy for general cadre officers for promotion to MMGS 2 and MMGS 3 for implementation with effect from the current promotion years, that is 2007-8.
it is.
8. Why?
No, but this he was in the zone of consideration in which year?
After post 2012.
No, 2003 and 4.
2003.
Yes, because he was in the grade 1. He was in grade 1. That is the reason why the learned single judge allowed him to take a grade 2 examination. That was in sealed cover procedure.
Yes. So
this is the subsequent.
Yes.
Therefore, that will not make any difference to our this one. What was the policy as on the
prior to 2007? That I'll need to, because I'll need to take instructions on that.
Because that will decide.
Yes, I'll take instructions.
Regardless of all these things.
May I submit?
Yeah. Do you have policy, promotion policy?
Yes, those have been given in the annexures. Kindly just annexure 9, my lord, of my consolidated writ petition. Page 39, madam, of my consolidated petition.
Page 39.
Yes, madam. But before going to this, my lord, my submission, submission is the order in that OJC that was never challenged by the bank.
OJC order said what?
Orders at what page?
Where is that order?
The order, kindly read out my.
We want to read it. Just give it a page number.
Page number 11, my lord. Kindly see third para. The said representation was not acted upon, and it appears from the writ application as well as the counter affidavit filed by the bank that on 11/1/1999, the bank proposed to accept the said representation dated 7/10/1998, subject to acceptance of 2 conditions. That is, the petitioner will be permanently debarred from getting outward for promotion and should not be permitted to officiate outside his cadre permanently. With these observations, these undertakings, they are offered to me, but I rejected because I wanted to take promotion and already applied for recalling my reversal petition. And the final judgment is, if that be so, on page 13, my lord, last line, if that be so, promotion of the petitioner to the officer cadre having been accepted by the bank authorities by permitting him to join in the promotional post and paying him salary for the period he worked in the promotional post, order of reversion cannot be passed without due process of law as the same amounts to punishment. And the order, the opposite council have said, the order was to be implemented within 3 months. But within 3 months, they have simply promoted me. I am allowed to continue, but for the orders for the interregnum period, the benefits they have not given. But
when benefit they should have given to you?
No, they are not. I'm going to annexure 9, my lord. When they have opened the seal cover, there are serious irregularities in the seal cover. I will just come to that, my lord. But prior to that, kindly see annexure 9. After opening the seal cover, page 39, they say that you have not been promoted. This language should have been not promoted, but they are saying that not suitable. But in the annexure, they are showing that by opening the seal cover, it is written not promoted. But here they say you are not suitable. So there is some mismatch.
Yeah, what mismatch?
Because for not promoted, not
suitability is a factor. Even
yes, I don't dispute, madam. I don't. But that means if I am promoted, I may not be suitable. That is my condition, my lord. If I am found promoted, but I am not suitable, I am not suitable for them.
No.
That is the case.
Apex court said in Indumati, even in seniority from merit based promotion, suitability is a factor.
Yes, I don't dispute. I say I'm telling my prayer is, if I am promoted with securing highest marks, but I am not suitable, I will not be promoted.
You will not be promoted.
Yes, that is the bias. They have until that is my contention. that even if I passed the examination, there are two examinations. One is fast track, a top examination, and the another is a general examination.
Those examinations.
Normal track. Those I have with thumping marks. I have secured highest marks in those tests. Those two channels I have successfully completed, but they didn't allow me to promoted. Even if I am just coming to that. But kindly see Annexure 9. And the second para, they say, we also, that means they have, without contending challenging the orders of the Hon'Ble Court, when they understand that they have done a fault and that is a mistake or they have done a wrong thing, they say, we also advise you that your candidature for promotion to MMGS 2 will be considered for the promotion years 2004 and 5, both fast track and normal track, 2005 and 6, 2006 and 7, 2007 and 8, 2008 and 9, 2009 and 10, 10, 11, 12, 13, like that. So that is my consensus before Lordship is, they have accepted that I have a right to be promoted, considered to be promoted during the interim period. But subsequent to this order, this letter, there was a promotion channel. I was not recognized. In that promotion, 427 candidates were promoted to scale 2. 427, without written test, without IOS. But I was left out alone. Even though I was in general selection by this order, they did not control me. And after several repetitions, they did not reply. But what they reply to my application is something must to be considered, my lord. Annexure 11, my lord. Lord, they reply that as per the promotion policy, best 4 years out of 5 years of ARF marks, that is what the council is telling, in the current grade, that is in the JMGS 1, are required for consideration of the promotion to MMGS 2 for the year 2013 and 14. As per the revised policy applicable for that particular year, 13-14, since Shri Pati, that is myself, had not completed 5 years of service as an officer at that material time, his case was not considered. My lord, they have allowed me to continue as an officer from a back date. By this time, I have already completed, say about 12 years in officer post. If that 12 years more than that, they have allowed me to continue. But here they say that you are not, you don't have any AR marks. But my lord, the shield cover they opened. The shield cover was maintained 2 years after I was, 6 years after I was reverted. So in that case, I was also not having the required ARF marks. So how can they complete a process and say that you have been not suitable, found not suitable, or you are not promoted? The ARF marks they contain to be prerequisite for your promotion. That in 2013, they forget to calculate that in 2003 and 4. So that is the bias, that is the rancor against me they are pursuing, and that is and my lord, in KB Rajoria case, what the single judge has appreciated. No junior shall be left out, no senior shall be left out when a junior is promoted, even getting a chance of promotion. That is the contention. And my lord, whatever Lawrence in counsel for the bank is presenting, those are all their wrongs. And for their wrongs, this could have been completed. So they cannot claim anything, any rule or any interpretation of any rule law in their favor, because it is their wrong only. Taking advantage of their wrong, they cannot do that. But my contentions, my prayers are limited to molding of the order to the effect that, because I understand from the bank authorities have their practice, my practice, that their practice that they continue to harass me like this. So if I am getting a at the initial stage of my promotion, that is scale 5, that is already the order of the Honorable Single Judge, then the pension amount will be very less. if my seniority is counted, then I will get justified amount of pension. And my lord, I may suggest, I may just, there is a recent order of the Honorable Supreme Court on 30th January. My lord, is similar in the case. On the first page of the judgment,
Give the reforms.
my lord, it is in Supreme Court, writ petition number civil 1180 of 2025, Captain Pramod Kumar Mahajan versus Union of India and other. On the first page of judgment, the Honorable Judge observes, the present case discloses a sordid tale of targeted departmental vendetta, full of malified actions and protracted persecution that has compelled the petitioner to invoke the stand. That is the observation of the, and my case is similar to that. I have also filed a contempt petition with the lordships. That was decided in my absence, my lord. But after that,
Mr. Mukherjee, kindly be seated. Which paragraph? Only analyze this. Which paragraph is relevant to your case?
Well, it is the entire judgment covers the aspect that when the officer was not denied a promotion because the alleged contemner is one of the person in the selection procedure, he didn't allow him to promotion. Thereafter, he went to court. Court gave some direction. Appellate tribunal also gave some directions. They are not followed. In my case also, similar practice has been undertaken by the bank. It is contumaciously they have disobeyed the order. This is a targeted manner since the day one. Since the day one, I may just draw your attention to the annexure 19, my lord. When I visited the bank to meet the officers, one of the officers says the container in that contempt petition number 6 that we know how to implement the court orders. And please learn that Honorable Court cannot make us do what we don't want to. That I have represented.
Without basis, his contempt is dismissed. He makes a statement which is this
is just an act.
What are we trying to do?
This is an evidence. As per res gesta is concerned, this can be accepted as an evidence because that is what I have been told by the officers, and that is what they have been doing since the start of because they know that they have failed to achieve any judgment in their favor because that's their mistake.
Please hold, sir. Res gesta will be taken here. Res gesta will be taken here.
No, that's
Section 6 of the
before Lord Massive, that since the day one they are trying to harass me. Since the day one,
in the DPC,
my lord,
one of the members was a person who was an accused in the contempt proceeding.
Yes, that is in the case, my lord. This case.
That way I'm reading. I'm read it at page 45, paragraph 45.
Yes, my lord.
In your case, how can you invoke this decision in your case?
This is also in my opinion, my similar submission before lordships is this is a targeted departmental vendetta. That is my submission, my lord. They say you are eligible to appear at the examination.
Did you take up that contention in your petition?
No, I'm not mentioned.
Then how can you argue all that? You are in appeal. Your pleadings, whatever stand you had taken in your petition,
My lord.
that stand you can argue before us.
My lord,
Why that single judge's order is wrong? He has directed giving.
My lord, yes, my submission is, my lord, with that effect. I can read out the KB Rajoria's order, my lord.
That is also considered in this judgment.
Yes, my lord, that is considered. But I just seek that the pensioner benefits should be proper according to my seniority and with some compensation for the loss I have been subjected to mentally, physically, financially, emotionally, everything. That is my simple prayer before all these lordships. The single, not a single one, the honorable single judge has observed in his
The order appears to be
Order, my lord.
balanced order.
Yes, my lord. At page 8, para 18, the honorable single judge observes the two moot questions he has to decide, that is his perception. First, on the promotional entitlements, and second, about the benefits that can be extended in favor of the petitioner. So the promotion aspects, he has the honorable single judge rightfully considered. I am obliged for that. But some pensionary benefits would be appropriate in my seniority case, and some compensation, because this is my, in this case also, the Honorable Supreme Court has been pleased to award some cost. Because that the gentleman who was the petitioner there, he has only 3 months of service left when he was
victimized.
So my victimization is more than 20 years, my lord. I am suffering for more 20. Even after retirement also, I am suffering.
No, 20 years means the matter which was pending here.
Yes, my lord.
The compensation has to be paid by the judges who kept the matter pending.
No, my lord, my sincere prayer is before yours. This court, my lord, this honorable court is not a mere court of law. It is a court of justice. So I pray before lordships that substantial justice, my lord, for molding of the judgment.
Were you a union leader?
Yes, that
you by your performance.
Yes, my lord. I belong to a different union. That is why all this has happened. They represented the recognized union members. They have influenced the management to go against me. That so this is my date I have never mentioned because it is very difficult to. It is very difficult to, my lord. That's why I have never uttered this anywhere. But my lord, for molding of judgments, I am just reading out a judgment by Justice K.V. B.R. Krishna Iyer in AIR 1975 SEC 1709, where he says, equity justifies bending the rules of procedure where no specific provision of fair play is violated with a view to promote substantial justice.
What is the name of case?
My lord?
What is the name of case?
Name of case Pasupuleti Venkatacharlu versus the motor and general cadres. With a view to promote substantial justice, subject to, of course, the absence of other disentitling factors or just circumstances. We affirm the proposition that for making the right or remedy claimed by the party just and meaningful, and also legally and factually in accord with the current realities, the court can, and in many cases must, take cautious cognizance of events and developments subsequent to the institution of the proceedings, provided that the rules of fairness to both sides are scrupulously obeyed. Well, they have tried for 20 chased me and harassed me. But if they are, I'm just...
where is the pleading to that effect?
And in my writ appeal, I am submitted.
In writ petition, you have to. You can't give.
And in my appeal, I have submitted, my lord.
In the writ petition.
In the petition, the writ petition.
Yes, it is there, my lord. In the writ is there. In the writ is there also, my lord.
Is continuation of the original petition.
Yes, my lord. I'm just reading out the relevant position versions of from my prayer. In the prayer has been modified, my lord, because I was retired by that time. My prayer has been allowed to be modified by the honorable single judge. And my prayer is that in the above premises, and in the changed circumstances of having retired from active service as on 31st/10/2019, the petitioner in person prays this honorable court to be pleased to allow this writ petition, and while setting aside all the rancorous representations at para 1 annexure 9 that I have said, my lord. My lord, I'm just submitting. During the course of the case, I have applied several miscases and IEs. Those could not be considered by the due time. But to appear from next higher promotions and to be selected, because I know my capabilities in the examinations, I could have passed, but they did not want me to get to that, so that they have, and the honorable court could not have considered the miscases. And while disposing the miscase number 743/2015, IA number 6177, IA number 7010, and number 1.
Any rapprochement is possible?
That I'll have
This
to
is,
take instructions. That I'll have to take instructions from my client.
Yes.
I'll ask them to.
Little this side, that side.
My lord,
Otherwise, you argue, he has argued now.
Yes, argued. I have.
You argue your case and.
No, my lords, I have not argued in the sense that I was referring to those circular, which your lordship pointed out is of the year 2007-8 and would not apply to him. But the fact of the matter is that that is also being referred to by Mr. Pati during his submission, which is extracted at page 45. So I believe, I don't know, this is subject to verification, that these same rules were also applicable to 2003-4.
Yes.
Because they are extracted here, they have been referred to, and they have not been disputed.
What is wrong with the order?
Yes, my lords. What is wrong is this, my lords. My lords, may I take your lordships to the order? Certain portions of the order, and your lordship may take page 20. Yes, ma'am. Kindly take page 30. Page 30 of the brief, page 5 of the judgment.
Judgment. Page 5 of the judgment.
Yes, page 5. Paragraph 7. In subsequent years also, he was called to appear at the promotion test in May 2014, August 2014, January 2015, but he did not appear at any of the written tests for promotion to MMGS, which is the first stage of promotion.
This appears your contention.
This was my contention, and this is not disputed.
Yes, it is disputed, my lord. Disputed. My lord, the single judge, honorable observes.
Let me complete my submission. You can show where the dispute.
Sorry, sir.
Please. So these are undisputed facts, because these are again reiterated later on in the judgment. I will come back to that. Next, your lordship takes paragraph 9 at page 31, about 8 lines into that judgment. Since as per the promotional policy of the bank, an officer is to be promoted to a higher grade, has to complete mandatory years in the existing grade and qualify in the written test, as well as the interview, and fulfill other criteria, and the petitioner having chosen not to participate in the evaluation system, it is not possible on the part of the bank to consider his suitability or promotion or otherwise. These were our contentions. Now, how has the court dealt with them? Your lordship may take paragraph 31 at page 37. The opposite party bank has miserably failed in honoring their own commitment and promise to consider the candidature of the petitioner during the here specified in the letter dated 1/4/2013. The authorities have fairly admitted that after considering the case of the petition for the promotion for the year 2003-4, they only considered the case of the petitioner in the year 2013-14. That is, after the judgment was delivered. The judgment was delivered in 2012. Therefore, the claim of the petitioner with respect to violation of legitimate expectation is fortified. The promised commitment to consider the case of the petitioner year-wise under the different channels from 2004-5 till 2013-14 has been violated ex facie, and non-adherence to such commitment is violation of...
Your own letter said that. Which you have read.
My lords, true. My lords, when did the cause of action for considering him for promotions arise? That consideration did arise post the judgment?
No. It arises because others who were similarly circumstanced were given promotion.
My lords,
that's the law.
No, true, my lords. But when the matter was sub judice before this honorable...
You could have said that. Sub judice, because, see, he is successful in the matter.
He was successful.
If he were to lose that, your argument would have held water. Not otherwise. Apex Court said, 76 Supreme Court, the right to promotion arises in the case of non-selection boards when the other colleagues are promoted. That's the law.
True, my lord. But for considering him for promotion, there are certain because it is not only on seniority. No, it is seniority come merit.
It is senior.
So how do I evaluate the merit, my lords? I am a creature of the statute. I am bound by certain... Sorry, man.
In the cases of seniority come merit.
Yes.
Merit takes the back seat.
No, my lord.
Merit is in the sense, the seniority is the rule. If you have adopted a particular procedure, you had promoted how many people?
427.
427 people without any examination and without any test. Yes, it's on recording. Only why for this person? If you had, now you want to rely upon that decision, we would have agreed with that. Had you subjected those people also to the same rigor, not otherwise. So simply, this is what Ramajoy writes. Justice Ramajoy writes in his services under the state. Even Samaraditya Pal. Let's see. Had you conducted
test for those 427 candidates,
you could have told him, brother, for them, they constitute a separate class because they undergo test and other things.
My lords, it's like this, my lords. It is not the test alone. It is also
without any examination.
Yes.
As the kettle would go.
No, my lords.
That has been done in the case of 438 people.
No, my lords. It's not. It is not. That is not the case. As far as those 438 candidates are concerned, they may not. This is subject to a verification, my lords, whether they were subjected to test or not. But what they were subjected to is appraisal of their AAFR reports.
Only.
Yes. Now, AAFR reports are a sine qua non for consider because I have to, my lords, go by the rules that govern me, my lords. The AFR report
with you only.
They are with me.
Yeah.
So AFR report, on the basis of the AFR report, evaluation of AFR reports and performance of a particular officer in a particular cadre, he becomes entitled to be considered for the next cadre.
That is on normative basis.
Yes.
Provided, did you apply this to the 438?
Yes. Yes.
It shows it.
Yes. That material will show to your lordship.
I pray.
Definitely will show.
Yeah. I pray some submission.
You have argued your matter. They are arguing their matter.
I'm just supplementing what they said. Bank circular keeps on varying. I'm just quoting this circular. They said circular is.
Is he disputing the circular here, my lord?
Yes,
that is not done in the High Court. Before the single judge.
But what I am submitting is.
If he is disputing, I will verify. What the 2003-4 circular?
Yes, that is the same circular.
That is verified.
Well, kindly see Annexure 24, page 39 of my affidavit, ISA affidavit. There the bank circular says, there may be officers due for consideration from promotion to MMGS 2 and MMGS 3, not having the required number of ARFs written on them, and the eligibility persons includes probation period of 2 years. Training period reports in such officers may be converted to equivalent ARF, rating marks for the above purpose and preparation of promotion appraisal form. That means there are ways and means how there are also circulars when ARFs are to be done away with, assignments are to be done away with. There are circulars because bank is putting them to assignments. We individually cannot go to any assignment. That after even after they then annexure 6 message, they reply to my prayer. I wanted to be
Your
pushed on
Lordship
assignments.
see the evaluation of those 427 candidates. Your Lordship may grant me some time because I'll have to get those things from the office, local head office at Bhubaneswar. And as far as the policies are concerned,
where is that contention that without any test or anything, these 438 people were promoted?
I've submitted that annexure 10, my lord, in my original consolidated writ application.
Annexure 10?
Yes, my lord.
Go to annexure 10.
My writ application, consolidated application, my lord.
In the petition.
in fact, the prayer that he read out is not available with us. I don't know. He says if this prayer for amendment was allowed and modified prayer was there.
My lord.
I don't know whether.
Which page you said?
Page 40, my lord, annexure 10.
40.
The candidates' numbers have been serial 427. Promoted with effect from 6/8/2013. And on this occasion, they had promised me that we will consider your case, but they go back on their consideration.
No, for these people, no test and nothing else conducted.
That is there, my lord. I'll just.
Where is that?
I am going to. Even not for scale 2, my lord, scale 3 also. The same procedure without any written, only viva voce was conducted. I'm just going to that. It's there, my lord. I'll just show you. I have submitted, it is there something, but it is circular. For scale 3, it is there. For scale 2, it is somewhere. I'm just missing out. On that particular year, there were no written tests for scale 2 and scale 3 as well. I'll just get you, my lord. But my contention is, heads they win, tails I lose. This cannot be the principle, my lord, as per them. They say 2003 and 4, your case has been considered, you are not found suitable. How can they accommodate the ARF marks? But here they say you don't have ARF marks, we will not consider your case. These are double standards, my lord. So that is why I'm paying my performance. It is continuously they have disobeyed the orders, and this is a targeted vendetta.
Lordship may grant me 15 days time.
My lord, my prayer is only
let them produce that.
Yes.
That they are saying that for all of them, some process they were subjected to.
My lord, whatever that is, why I could not have any ARFS? Is it because my
call up 2 weeks at the request of the appearing for the any date you need, you have to come from.
After 18th, any date.
Which place you have to come from?
Cuttack from Cuttack.
Cuttack only?
Yes.
Then I'll be checking.
Item 15?
He must say something.
Already here, petitioner will not within that commercial tax officer. During his incumbency, he assessed one company that is Reliable Sponge Iron
and he gave the registration certificate to CORAM company. And he has issued 345 number of way bill. 345 number of way bill.
Way bills for transporting interest rate or interest rate. Way bill is required. Way bill.
Way bill.
What is the long form? That is called WAY.
Bills. Way bills for the transport.
Way bills.
I was under impression some new English word. I have never heard before.
Yeah. He had issued 345 way bills to one Tapan Enterprises. That is one of the dealer. It is stated that though that dealer has not filed any return, that is sales tax return during that period.
Whether in your state it is monthly return?
My lord, so it is quarterly. Under VAT, it is quarterly.
And though he has not filed that return, but without verifying the same, he has the return issued that 345.
Whether filing of a return is a precondition for that?
That is not precondition, but it needs to be filed. But that dealer, that is Tapan Enterprises, filed also. On verification, it was filed that enterprises filed. During that period, entire period he has filed, and he is not liable for any tax or penalty, because had that been so Millard, the authority could have been Millard taken and on that ground, Millard, for these three reasons.
Any disciplinary inquiry?
Disciplinary inquiry initiated against this petition, stating that you have shown undue favor to that Tapan Enterprises, and though you are not eligible to made any assessment of the reliable response, but you have assessed that, and instruction of the higher officers.
First is, you have shown favor to a dealer. Assessing millers. Second one is?
Second one is, as I have shown that favor, that's why the state loss
revenue loss happened to the state, causing loss to the exchequer. Three is insubordination. Insubordination, not complying with the instructions. Yeah.
That three charges were kept. And I also replied again to charges, explaining with the concerned.
You denied charges.
I denied charges and I
produced material also.
But that was not considered. Then inquiring officer Millard appointed. During the inquiry, I also Millard and the inquiring officer Millard discharged.
Inquiry of discharge you.
Millard.
My lord,
not true.
My lord, there were 7 charges. Inquiry officer found 3 partially proved, exonerated 4.
And those 3 charges which are held to be partially proved, whether that is insubordination, that is not following instructions, causing loss to the exchequer. Number 3, favoritism. Whether all the 3 were held to be proved. But partially proved means what? There is no meaning. Either it should be proved or disproved. What they said? He is partially corrupt, saying no. Corrupt or not corrupt?
My lords, what I submit, my lord.
Want to know what is the finding? What are the findings of the inquiry officer? Which
well, it's in fact the impugned judgment of the learned on the.
There is a criminal case also against you.
No.
My lord,
Yes. The criminal case was there. That is vigilance case on the possession charge. They have stated that as you have shown that only able to that. That's why it is falls under 13(1) of the PC Act, and that's why.
My lords, the Honorable Single Judge judgment is that you can revive your claims after the conclusion of the vigilance case. And in so far vigilance case is concerned, the charge sheet has already been filed.
No, that's all right. But the point is whether he is punished in the disciplinary inquiry.
My lords,
what is the punishment?
One is recovery of 10% of the loss sustained, that is 34 lakhs, and one increment, withholding one increment with cumulative effect. These are two punishments.
Recovery is not a major punishment.
My lord, but cumulative is
a major punishment. Can't you do something for
he has retired.
Cumulative.
He has retired, already retired.
Therefore, give up that cumulative. Recovery you sustain.
My lords,
appears to be that way. Brother will do that way.
My lords, I can't concede.
No, but with the one merits will say, because see, only one withholding of one annual increment with cumulative effect. Correct. 10% recovery you have made already.
No, recovery is not.
Recovery is not ordered.
Ordered.
Ordered, but yet to be effected. So what we suggest is, let them recover 10% recovery you have to. Because whatever state would have gained, that the state has lost. We don't say for a moment that it was with corrupt motive. But it may be a negligent act also, causing loss to the exchequer. Even when innocently you do it, still you are liable.
There are 4 persons involved in this.
Each 10%.
My lords,
who are given only censure.
Censure and one is 2 increment withholding with cumulative.
With cumulative. But what we feel is, going by our little experience in matters like this, one increment with cumulative effect you have done, that you have to forego. And recovery you can do.
Subject to that, vigilance case is also pending.
That will happen. It will take its own course. If in vigilance case is convicted, everything will go.
Yes.
Because they cannot also, their own notification. If a person retired when the charge sheet was submitted, because they have now charge sheet submitted in 2024. This person retired since 2018. Case was initiated on 2010.
This punishment was prior to that.
They are now stating after 14 years that we have to submit.
Report.
Whatever will happen in criminal case, it will happen. We will not say anything on that.
In their own notification, you will also may see that.
What it says?
That is.
It has been clarified.
It has been clarified by the law department that in case where a cognizance of the court has been taken for an offense of a government employee after the date of his retirement, it can be stated that no criminal proceeding is deemed to have been pending against him or her at the time of return. That means, my lord, by the time I retired, had that been cognizance against me is taken, then it is deemed to be that when I am liable for the sins. But by the time, my lord, I retired, no charge sheet even, my lord, filed at that point of time.
No. Not like that. Similar rule was interpreted by the apex court. This refers to your withdrawal of terminal benefits.
Exactly, that is
if your terminal benefits are not permitted to be drawn because a criminal case is pending. In that circumstance, this should be interpreted. Because your rule, almost in every state there is such a rule. In Karnataka rule, over 14.
This is rule 66. Rule 66 of the pension rule.
It says when a disciplinary proceeding is deemed to be pending, when the criminal proceedings are deemed to be pending, only for the limited purpose of that, they have made this. That does not absolve
He is
you from
entitled to
criminal charge at all.
provisional pension, but not
That's-
the regular and the gratuities can. But that is the rule, my lord. The statutory embargo is there.
And that apartment, if I convict, even if Millard, if they stated that even if I convicted Millard in that criminal case, then I will be Millard, that is for sentence and fine was there.
No,
So
pension
they
and
cannot
everything
recover from my pension, Millard.
Pension also will go. Say after conviction in connection with the criminal case, which happened during the
And that is not with regard to Millard. They stated that as Millard, so far that criminal case is concerned, Millard, that is with not regard to this also. Because in other case, Millard, there are number of persons are there.
Anyway, we will not touch that.
Millard.
What we suggest is we will reduce, we will say that increment part you give up, 10% recovery will retain that.
But not the regular pension unless the
No, that will after the
Conclusion of the
closure of the criminal proceeding.
but provisional pension has to be
Yes,
paid.
that is the rule. That is the rule, my lord. Lordship, ma'am.
Rule itself says that.
Yes. Rule 66 of the Orissa Pension Law. Rule 66. The lordship.
They must have been allowed.
Rule 66.
I will ask that person whether he is getting that provisional.
This is a petitioner or which is that? Appellant.
Appellant.
Appellant has already retired from service on attaining the age of superannuation. First off, criminal case in what do you call it? The criminal case?
Millard, that is
vigilance case.
Rule 66 against the petitioner. Petitioner. First off, out of 7 charges,
Well,
4 are held to be proved, that too partially.
3 men.
Three are held to be proved, that too partially. That is showing favoritism.
Not that, Millard. Those partially are not that. Because those super laws and all these are concerned, I have discharged.
Showing favor. Favor is proved.
Millard.
Showing favor to a registered dealer, causing loss to the exchequer, and not following instructions of the higher ups. These 3 charges have been proved.
No, Millard, these 3 charges are not true. Because so far the exchequer is, law to the exchequer is concerned, the finding of the inquiring officer that no, there is no law.
But did he not reverse it? Authority.
My lord, disciplinary authority has given
Reversed.
First off, though the allegation as to causing loss to the exchequer was not held to be proved by the IO, the disciplinary authority disagreed with that. Whether proposal notice was given to him?
Yes.
After following the proposal notice procedure. First off, pension retirees, how many years of service you have put in?
Millard, 25 years.
Correctly, you have to say.
Millard, he is got superannuation on 2018, Millard.
We are not
And he
asking that.
entered into service.
Any other disciplinary proceedings were held earlier?
No, that is not.
Petitioner has put in a long and spotless service earlier. 7 months. He does not have proven bad remarks in the service register. First, Apex Court has held that long and spotless service is a mitigating factor while awarding the punishment in a disciplinary proceeding. This aspect is not examined by the learned single judge. First, secondly, in respect of retired employees, it is observed by Karnataka High Court that they should be treated with soft gloves. First, keeping all this in mind, although the findings are kept intact, the punishment is reduced by allowing the recovery towards the loss of the exchequer, 10% recovery towards loss to the exchequer. But deleting the punishment of withholding of one annual increment with cumulative effect in the very fitness of. First, the provisional pension needs to be sanctioned to the petitioner, to the appellant, if already not sanctioned, consistent with the rule. Which rule it is? Rule 66 of Orissa Services Pension Rules 1982, subject to outcome of the vigilance case. Pending in the file of, on the file of
Vigilance Judge Hon'Ble.
On the file of
No, it is not in
jurisdictional.
now. It is before
All right, pending on the file of jurisdictional court.
Sundargarh.
Sambalpur support jurisdiction one. Structure there.
in that case, your lordship.
My lord, sorry. My lord, that item, the matter was placed for 2 o'clock today. They informed me that they have taken time.
Yeah.
So, no, it's okay. My lord has kept it for Thursday. If there is, my lord, I have another matter.
Which day you want?
No, I don't. Let it be on Thursday. If there is any problem, then my lord.
No problem.
No.
But in that case, your lordship, that as per Orissa pension rule, rule 7, if in a judicial proceeding, if the cognizance or even charge sheet has not been submitted by the time the person is retired, then it deems to be that no proceeding is there. And
that is for criminal case.
Yes, my lord, that is for criminal.
How we are not concerned?
My lord, but your lordship, the honorable single judge has held that that criminal case is pending against me. My all dues are subject to that finalization of that, my lord, because that was not in the charge itself also.
No, that makes no difference now. We are not saying anything about that. One increment which has been withheld, that we have given.
That
recovery remains.
That I am not in there.
Yeah.
But so far, honorable single judge held that criminal case is there. That criminal case is nowhere related to this proceeding. But due to that, I am unable to get any area.
Therefore, we told them to provide provisional pension.
That provisional pension I am getting. That is not there.
Regular, no.
So far, other
whether it is connected with this or not. Where a criminal case involving moral turpitude is offense involving moral turpitude is pending, though not related to service condition, your pension will not be finalized.
That is not pending because what, my lord?
Criminal case is not pending.
My lord, that as per my lord, the rule 7, my lord. As per rule 7, if by the time a person retired, if no charge sheet is submitted in that case, then it deems to be that no criminal case is there and is entitled for all the service benefit. You will also see that rule 7, my lord, of Orissa pension.
But now the charge sheet has submitted in 2024.
Well, after that.
But that case will go on. What he is saying is, for withholding of the pension, for non-sanctioning of the regular pension, the only ground is pendency of the disciplinary proceeding or pendency of the criminal proceeding. What is meant by pendency of criminal proceeding? The rule says, according to him, there are such rules in other jurisdictions also.
Then no,
If the
Lord
charge
has
is
reiterated
not
time and again that on only cognizance from the date of cognizance it will
not
be
even cognizance.
no
Filing
charge
of
sheet.
charge sheet.
Filing of charge sheet. Then it will be deemed that there is a proceeding.
Then it's a criminal proceeding. Unless
a charge sheet is filed. No, Lordship is absolutely correct. But it's a twofold, my Lord. Only.
What he says appears to be.
No. The rule 66 may have a conjoint reading with rule 7. Now the clarification has come. My humble submission that if the criminal proceeding is not deemed to be not pending, then the disciplinary proceeding was pending and punishment was imposed. Then that is that rule 7 says, if disciplinary proceeding or criminal proceeding. If criminal proceeding was not there, then disciplinary proceeding was there, my Lord. Then how can the...
But now, that is now, it has attained finality now.
Yes.
With our order.
Yes.
So you have to sanction.
Your Lordship interfered with the punishment. Your Lordship reduced the punishment. Thereafter we will finalize the...
Instead of a parental pension, it will be done.
And to that effect,
since the appellant has retired from service and attaining the age of superannuation, and that the criminal proceedings in the the vigilance case is not deemed to be pending.
Was not deemed to be. Now it has been charge sheeted and
was not deemed to be pending as on the date of retirement for want of filing of the charge sheet.
Yes.
And further, the disciplinary proceedings having attained finality with this order, the petitioner, the appellant needs to be sanctioned the regular pension.
And all the service benefits,
and all other consequential benefits.
But my humble submission for consideration of your Lordship is that if by the process of time the pending adjudication of this matter before your Lordship, the charge sheet has been filed, cognizance has been
taken. No, it cannot be. Point for reckoning it. In fact, Justice Shivshankar Bhatt of our Karnataka, a great judge, he has considered.
Division bench of this Hon'Ble Court has
most of the high courts have taken them.
As the situation prevailed then.
Yeah, as it prevailed then. That's how it is actually.
Grateful.
He's right in telling that.
Grateful.
Okay. Sorry, we did not appreciate that early.
No, that rule, it was not cited before your Lordship. It was not cited. Conjoint reading 66 along with rule 7.
This view is because of a reading of section
7. Rule 66 read with rule 7.
7 of pension.
Conjoint reading.
The good 7 of pension rules 1992. Okay. Yes.
Item 17.
When we judge this error, you should point out it has happened like this. And we are going to rectify our view or judgment. Otherwise, injustice will be caused to the client.
That is the beauty of this system, my Lord. That is the beauty.
All that matter. In fact, in this matter, my Lord, the disciplinary authority and the appellate authority is the same and one person.
No, that is not correct. I have examined. It was not raised. Now it is being read. I have examined. It has gone to the level of the Chief Minister. Chief Minister has decided that on behalf.
Chief Minister is also
Governor.
Next.
Item 17.
Item 17, let's make a single password. Let's short password.
That's it. Password.
One password. Careful.
Item 18.
Item 18, my lord, just to refresh your lordship suggested some figure to me.
Pink figure you can say.
It in fact, my lord, was found to be a huge exorbitant figure. The MD who will take the final decision, my lord, he is only absent for a day and a half. Tomorrow, post noon, he will resume. What I pray, my lord, my officer is also there to watch the proceeding.
My lord may kindly fix on 20th. I will file one short affidavit indicating how much amount Federation proposes for one-time compensation as paid for the by the opposite party.
Hold on. 20th?
Or any date convenient to you. I'm sorry.
No, 20th we are not sitting there. 19th we shall have.
Any obliged 19th.
Like the request of, but.
Item 19?
It will come in orders, my lord.
It will come with. Don't do it. Yes.
May I please, Lord? The petitioner agreed by the order dated 27/1/2025, passed by Lord and Cat Cutup by the annexure 5 at page 122, wherein his prayer, one prayer is allowed and another prayer is rejected, though this same has been set at rest by all the Cat by of different Mumbai bench, Bangalore bench, and also Rajasthan bench. Your Lordship may kindly see.
OA is allowed.
OA is allowed, but one part was allowed, that is so far the recovery is concerned. But so far the refixation.
Recovered amount of rupees 2,01,956.
Yes, my lord.
From his gratuity.
Yes. But
within a period of 60 days from the date of receipt of a copy of this order.
But the fact that, just I will clarify, Lordship.
With 8% interest.
Your Lordship may kindly see page 127. 127, para 6.
This is Rafiq Masih.
That is Rafiq Masih. That is so far the recovery is concerned. So far the entitlement and concern, what they did, first we are getting special pay. Special pay in lieu of the in view of this more responsibility. That was allowed in 1988. In 1988, in 98, what happened? The special pay was turned as a special allowance with it doubled. So at that time we are getting 90 rupees. There we got 180 rupees as a special allowance. In the fifth CPC, the word came into that those who have got 3 years special allowance, their pay, that is 180, will merge with their pay fixation, with their pay in their promotion post. This was allowed in 1999. I retired in 2021. They, on the basis of audit report, they withdrew that at 180 rupees. That means my pay was reduced from 68,000 to 66,000. This problem arises in throughout many states. Yes.
Various tribunals have taken the view.
Yes, your Lordship may kindly see the Mumbai bench judgment that has paid.
What the tribunal says? Why? How tribunal did not?
Your Lordship may kindly see. The tribunal same bench has passed a similar order, but in my case, though relied that order, but bypass that objection. That I am giving that judgment. That is Ganesh Kumar case.
What is this, Mr. Pari? Why tribunals are doing like that? In the identical set of facts, how the tribunal has granted the relief. He find other tribunals in the country.
Your Lordship can see that orders I am passing you. Ganesh Kumar case has been taken into consideration by the tribunal. There are also 2 prayers. Your Lordship kindly page 12 of that judgment. There, after para 5 second para, kindly refer to above mentioned case on a further course of action to be taken on the judgment dated 4/20 by the Hon'Ble Cat Mumbai bench, first bench, on way number such and such. The case was referred to Department of Expenditure, Ministry of Finance for their service, Department of Expenditure by their diary number such and such, dated such and such, has agreed to the implementation of the Cat Mumbai bench, order dated such and for the applicants only copy enclosed. 6 para 6. Lord and counsel for the respondent.
Kotraya in Lalita.
Yes. That's the report. Para 6. Lord and counsel for the respondent consists to the fact that the aforesaid order has been implemented. Then your Lordship may kindly next page. Para 5. Since
the facts and issues involved in the
instant case as discussed above are same and similar to that of the case of Sanjeev Kumar, That is Mumbai bench case where the applicant being similarly situated as that of the present applicant were also agreed by the order of a recovery due to reduction of their basic pay. That is 180 rupees. And they had also prayed to restore
That has been granted to the applicant.
and his pay was restored to that original position.
Same position has to be given to you.
But they say that if there is no justification, you will speak.
Last time we read that.
Yes,
it
right.
only says bad it is bad in law in any manner because the respondents have every authority to rectify the mistake. They cannot say that, Mr. Pari.
But
How can that be?
It is listed for first time or taking
No. Notice was issued.
No, not first time.
But let's come to our counter.
Yes.
In 102.
Please.
Page number 102.
No, that we will look into. The very same persons have been granted the relief in respect of same department by the very same tribunal.
There is no dispute, there is not same department. The dispute is there. He has joined with a different position, again changed to another position that I wanted to reflect in. So this case, where it was implemented, that cannot be taken as a similar nature and for which it will be considered in this case.
When you holding different position.
No, that is then clearly kindly see.
Claim is separate, is not equal with the pay which was given to him by the other tribunals. That was categorically stated. So I am just clarifying that.
Only
that's why the tribunal on one page 125 is clarifying this.
Page 125.
Page 125.
Now, where is the discussion by the tribunal? Tribunal says
it was in page 125. May I read?
Yes.
While preparing the pension papers, the account showing of the department objected the fixation of the pay of such and such on 21/3/2019 up to his promotion of the TBUP cadre, and according to the account showing, the pay of the applicant should have been fixed to 5,000 as on date of his promotion up to TBUP cadre instead of 5.25. Since the special pay of 120 is not the component of pay, accordingly it was suggested for refixation of pay and recovery of the something.
That itself is wrong. You cannot be selective in that. If the departments are interchangeable, regular post and RMS, the same person can work here also. He can work in the other department also. They are part of the postal department only.
The fixation was wrong.
How? Why?
Because even though instead of 5,000, it was fixed to 5,125.
Correct.
Yes.
But the other persons who are in the same cadre, you have given that benefit. No, you cannot say like that.
But that was not happened. That was not happened. It was the correction. Whatever basic pay of 5,000 is taken care of.
No, it becomes the other 125 becomes part of the component.
So what I'm paying, then Lordship may give 1 to that time I will re-examine and I have clarified. Then the short point is in authorized.
That is conflict between special pay and a special allowance. It was a special
pay, not allowance.
Yes, but
allowance will not be part of the component. Special pay is part of the component.
In 98, it was
that famous judgment by Apex Court. The special pay is part of the component. Yes. Special allowance is not.
But they are surprised that special pay is termed as a special allowance.
No, you can't.
No, they have filed their and accordingly, all the courts have allowed that and it was categorically held by Mumbai bench and Bangalore bench and also Rajasthan bench and municipal bench also. And on that basis, this poor also has got same benefits. Same like what they say, you are not
saying. Similar or natural case is the Hemant Pani. This case was penny pretty good. We have challenged this.
So we call that matter also.
Lordship picture this matter.
You give that number.
I'll give. He will give.
Call along with the so next week.
And it was clarified that same special pay and what they say.
Therefore, what you call it as is also important.
Yes, ma'am.
If the nomenclature is wrong, consequences will be.
No, they have clarified. Government has clarified special allowance and special fee is same. Same. It was but termed as a special allowance by virtue of 22/498 circular.
Yes,
It is the same. And it was clarified by Swamis and also by all the tribunals, and it was also clarified by the High Court of the Karnataka High Court.
Do you have Swami's compilation?
Yes, my lord.
Which is that?
That I have also annexed there.
You annexed it here?
Yes, sir.
So show one copy to Mr. Pari also.
That is the annexed also in their in that at page 68. Yes, the annexed at page 68, my lord.
68.
No, the
compilation.
Extract
I have already come.
From the Swami newspaper. 18C. 18C.
Yes, my lord.
Page?
That is, I have annexed at page 68.
Which is left or right?
That is right, my lord. That is 68 annexed A by 10. Filed before the Law and Tribunal. In the special allowance granted in lieu of a higher pay scale is to taken into account for fixation of pay on promotion to higher post. In this divisions of PO RMS accountants are getting special allowance of rupees 180 per month in lieu of a higher pay scale and has rendered more than 3 years of service in PO RMS accountant post. The said officials are claiming that their pay should be fixed in TBOP in the next higher scale, that is rupees such and such. After adding their special allowance.
One copy, Xerox copy to Mr. Pari also.
That is
So that
part of record.
Just look into.
Can it be after 10 days?
We'll have it in the 26.
Yes.
Also that poor judgment maybe can kept in the records. That poor judgment I have
those will give you that day you just pass on. Again, we should not file it. We have noted now, we have understood.
Item 17.
Yes, sir. Yes, sir.
The Lordship may kindly say the last order.
5 to 26.
Milord.
And not may see the order 5 to 2020.
Yes.
Now,
what is the punishment?
Running page 112, internal page 55, paragraph 9. 2
increments with cumulative effect.
Yes.
What was the misconduct?
Mr. C is misbehaved with a minor girl.
And that doctor who took that photograph itself.
Yes, that.
No, I went again. We discussed that with the dentist himself. I discussed. In every prominent case, they take the photograph, and they cannot take just one particular part, cavity alone, oral cavity alone. They take both the face itself. Number 1. Number 2, we have read the file. When the photograph was clicked, parents were present. Parents of the girl were present. And he said, on your birthday, I shall present this photograph to you.
But simultaneously said that this whatever photograph that you not disclose your parents. Number 1. Number 2.
Parents were there.
Yes. No matter.
No, in presence of the parents.
But some other things are there. Because if it is a budgetly, fatherly or brotherly or elderly, he has taken something, I have nothing to say. the person who has done this, he has some antecedents. Antecedent means previously he has also some allegation is there, or which
That was in 2000. That was 2012.
Yes. And here is
It
the
was in
case.
2012. What before that?
He is confessed, my lord. He is confessed.
One is 2006.
Yes.
Another is 2000.
My lord is right. Yes.
Yes, I remember because other day you argued that.
Yes.
Therefore,
so in this context of
in
what
fact,
I'm
myself and my brother discussed about this for a quite long period. What would have been the circumstances under which all these things
now,
happened?
my lord, I am not stand on because my lord is examined it thoroughly. I can't stand on the but my limited submission for my lord is there. It should not be example for the department because even though he has done such a heinous work and he is exonerated from the court of law.
We are not exonerated. We are not exonerated.
So what I am praying, my lord, lordship should balance the society as well as the department also. Otherwise, what happened? This kind of things will be very bad impact to the society. That is only something. I could not go on the records because lordship has already digested everything. And
in fact, I was a little moved when I saw the allegation. I was moved actually. Kind of Dr. He, such a child, taking photograph and telling that I will present it to so and so initially. Then brother told, no, what happened is please see the entire the draft. Then I felt
I discussed many times with the officials. His conduct is not well. That's why they're keen to this punishment. Otherwise, something has happened and it's a minor thing. We should not be exaggerated and should come to this.
But you see, in surgery,
yes,
this is the practice actually. Wherever, especially ocular parts, with parts which appear to this one, to show to their other clients and make their profession more marketable. What they will do is, see, when that lady came here, she was looking like this. After plastic surgery, now she is like this. It is only to
it is a practice.
Nothing beyond that.
Yes.
And see that is a child.
But if this should be the practice and we have nothing to say. Here in the case, exception is this: the person who is conduct is not fair. He is always
one increment. What two increments?
Three increments. Three increments for 5 years.
5 years.
That was started from 1/8/2018 and ended on 31/7/2023. The day I am superannuating, my lord.
Sir,
with cumulative effect.
Only one thing I
You
was
also-
highlighting code. Let's say 154. Let's see this page 154.
154.
154.
Things happen.
Proceeding minors and question from the IU, PU to CU. Then let's see. Question number 2. Are you supposed to take photographs of any patient in the dental rooms as per your charter of duties? He says no. Are you aware that
Mr. Padi, all through this delinquent is fair. He has never denied anything. All through he has said yes.
That part
he has admitted.
Yes,
Even on the
he's
fairly has said.
Appears to be naive fellow, not exposed to the world affairs.
Discipline as a defense that to employ doctors. You should not go cross the Lakhan Rekha. My humble submission to this.
No, there was no Rekha at all.
That is of 87.
Here, there is no contiguity. 2006, 2012. There is no time contiguity. Even Angulimala and the author of Ramayana. All these. It's not therefore. By one single act, we cannot do like that. The other two acts have no the contiguity. What was our suggestion earlier?
But your lordship, in fact, I have suggested that if your lordship will please to cumulative effect may be taken away. Now, my lord, little prayer more, my lord. that expiring on 31/7/2023, the last day of my retirement. That may be little bit earlier so that I can be restored, my lord. Nothing else. I demand nothing more.
You retire on which date?
31/7/2023, my lord.
31/7/2023. Which is the date of accrual of the increment?
Last, my lord. That is
no.
Increment is
increment is annual. It is. Mr. G, which date the increments accrue? First day of
July. First day of July. My lord.
1/7.
Only I want that restoration.
1/7 particular.
Yes.
1/7 of that
particular year.
Yes.
23 means
then if it is 1/7,
yes,
retirement is subsequent to 1/7.
Yes,
subsequent to 1/7. Because they are convincing, all these things are going on.
Yes.
In the meantime, we got the interim order. So the department also helpless to do anything.
Only
order. Go to the earlier order. 5/2/2027. Suggested for a lesser punishment than what in the entire proceedings of case. Submitted 9 cases in principle agree with the suggestion provided that cumulative effect is removed. Only thing is cumulative effect to be removed.
Yes, sir.
That is not his suggestion.
That was my Malad humble prayer.
Of 3 increments. Without cumulative.
That I will take, Malad. I will take that 3 increment for 5 years. But one
without
thing,
cumulative effect.
Without cumulative votes. I pray that some 1 month, at least 1 month.
No, that cannot be done.
Sir,
1st of July it goes.
Then 1st of July, then my 15 days even, so that it can be restored, Malad.
It cannot be done. It's not a matter of recovery. It's accrual of increment.
No, Malad. I am not asking for the increment also. My humble submission.
Ultimately,
yes. I am retiring on the last day of punishment. Therefore,
in this way, they are.
I am retiring.
Do that. Not.
I am retiring on the last day of retirement.
We have understood your point. What you are suggesting is your client will get more pension. The last pay will be increased. Therefore,
restored.
Therefore, he will get more pension.
Yes.
Last pay run is there.
But you have said other day that see this. The counsel appearing for the OP very fairly submits that his client is in principle agreeable with this suggestion, provided that the cumulative effect is.
Yes, Malad. I am not going back, Malad. My humble submission, that cumulative effect may be. That restoration may not be happen because of
cumulative effect to be not with cumulative effect. Withholding of 3 annual increment without cumulative effect to be. So it will be partly allowed.
Yes, problem.
Send it to us.
Sir. Item 20.
Okay. Let's make it to next week then after 10 days.
Which one?
Item 20. M's matter, one doctor.
You'll have it in the first week of March?
Yes.
There is interim order.
Interim order be extended.
That. Great. Call this matter in the second week of March. You'll have Mr. Parikh. Because first week we have already posted. In the second week of March 2026, at the request of the bar, first up, interim order to continue till then.
Great.
Item 21.
Yeah.
There are
2010 matter.
Yes, your lordship. Well, here there are 3 matters. All the 3 matters impugned order is 1. So let me clarify the background of.
Who is your opponent?
State.
Yes.
Well, here an advertisement was issued on 26/10/1998. Pursuant to that advertisement, 26/10/1998. Pursuant to that advertisement,
for what post?
For the post of junior assistant, having regular scale of pay. Here the point, because I am saying the regular scale of pay, because the point is here, when the tribunal has held that the action of the government by appointing the petitioners on consolidated basis is illegal, but directed that we are to be regularized from the date of the order of the tribunal. That is just merely small campus, narrow campus, this order is before your lordship. In this case, some other persons agreed, because that batch of OAs were disposed of, some other persons agreed, they filed some other writ petitions. Those writ petitions were dismissed. They went to the Supreme Court, and the Honorable Supreme Court held that since the claim for regularization was not being dealt with by the High Court, the matter was remanded. In their case, not in our case. But why I am saying this? Because the impugned order is one tribunal's order. So that order was challenging the Supreme Court. Even Supreme Court has directed that the matter to be decided with regard to the regularization afresh. In those writ petitions, the matters were again was listed for hearing, but nobody was appearing on their behalf. Those writ petitions were dismissed for the non-prosecution. And after that, CM appeal was filed for restoration. Those have been also dismissed. And against that CM appeal order, they preferred the SLP, and that SLP is dismissed. But here the point is, the direction issued by the Honorable Supreme Court for a hearing with regard to the claim for the date of regularization, that is still there. These writ petitions were kept pending because awaiting the disposal order from the Honorable Supreme Court. And the Honorable Supreme Court remanded the matter. After remanding,
considering whether regulation aspect to be considered.
Yes, Your Lordship. Understood. Here the tribunal's order, Your Lordship, will find at page 54.
You went to tribunal with what prayer?
My Lord, for regularization, challenging that our appointment on consolidated basis.
See, show that prayer. Prayer column in your way.
My Lord, way petitions were not.
That is not been annexed, my Lord. That has not been annexed. Annexed. That is not annexed. Available.
But the prayer has been.
It has to be examined.
Page 56.
But without way, you file writ petition. How we should assess where is the error apparent on the face of the record?
The order of the tribunal is there. But then we can.
Might have given, may not have dealt with how to.
Anyway, now 2010 matter.
No, let him produce that.
No, that will not help us. We can't keep 2010 matter. You have seen what the
only 2 to 3 days will not grant it. Next week.
Will you produce it next week?
Next week.
Next week I can produce it.
Call this matter next week.
Before to that, kindly see page 63. Not the London page? Page 63 of my brief. Your Lordship is holding 22139. Because
22142.
No, 22139. I'm placing 22139.
2239
is the with matter.
With, yes.
Matter.
Page 63, last paragraph. An issue has been raised as to whether candidates who have been selected by the Staff Selection Commission for regular appointment as junior assistant in a fixed scale of pay can be offered appointment on a consolidated pay of.
Where are you reading?
Page 63, last paragraph. From an issue.
An issue has been. As
to whether candidates who have been selected by the Staff Selection Commission for regular appointment as junior assistant in a fixed scale of pay can be offered appointment on consolidated pay of rupees 4,000. In this connection, I am to submit that just because a candidate has been sponsored for appointment by the Staff Selection Commission, there is no right conferred on him for appointment. The Staff Selection Commission had sponsored their names as back as on 16/1/2001. and in the normal course of validity, the panel should have expired a period of 1 year. Thus, the appointment at this stage in a consolidated pay of 4,000 is not violative of any right. But as a matter of abundant concern, administrative department may be advised to get willingness from the candidates for the appointment on such consolidated pay in advance. This was the noting has been reproduced, the noting of the government. In view of this, we may implement our earlier. My lord. The present view that a candidate sponsored for appointment by Odisha Staff Selection Commission can have no right for appointment to be read in the context of fact, the concerned authority should have taken into account the fact that vacancies were publicly advertised, examinations were held.
Been forwarded, reasonable expectations arose.
My lord.
Well, that was the situation.
That was the situation to issue appointment orders with the inferior terms and conditions without any prospect of entitlement, consolidated salary of 4,000 per month.
Who said this? Para 6 is by whom it is?
By the tribunal.
By the tribunal.
And concluding they have concluded a department to take a final decision at this own level, as if he was arrogating himself the power of the government. We find no justification to deprive the applicants of the regular scale of pay as per the advertisement in the guise of austerity measure. The learned government advocate submits that in any case, by way of abundant concern, the willingness of the applicants was taken to the terms and conditions incorporated in appointment orders. The learned senior counsel for the applicants, on the other hand, submits that being stricken in unemployment for a long period, when they were about to cross the upper age limit for entry into the government service, the applicants had no other option than to accept it to earn something for their livelihood in these.
So I understood now. Come to para 8. He says, from the date of this order.
Yes.
That is your grievance.
Yes.
It ought to have been from the date of entry into service.
Entry into the service.
But at this length of time, how can that be done?
My lord, here the hour
service can be counted at the most, but no monetary claim. Where state will be bankrupt.
Notional fixation can be done. Notional fixation can be done.
Notional fixation.
We pray regularization, seniority
because
regularization.
of that observation, the tribunal is not justified in saying from this state. What is his fault? You approach the tribunal when?
My lord, that 2006, my lord.
2006.
Appointment, we were appointed 2004.
Notional will give.
Notional.
Yes. Service.
Because the austerity measure compelled the government to downsize the administration.
Very well.
Abolition of yes.
Advertisement is given. Examination has been held. They staked the claim. Interview has taken place. Appointment order has been issued. How can the government say we will not pay them the regular salary? Ununderstandable.
Because posts were abolished. There was no in the midst. In the midst.
Those are advertised. That another point is there. Whether they can change the rule of the game when the game has already started.
The super cyclone. If that happened, if they impacted, my lord, the government is to take austerity measures, my lord.
No, we are not. Therefore, austerity measure is in respect of emoluments, salary, monetary aspect. Now we agree with you.
Yes.
No monetary aspect, but service to be counted.
Grateful.
Next one. This is serial number 21.
I don't know.
In all the three matters, it is like that.
Yes, it is like that.
All three matters.
Exactly.
I am appearing for in two. You will see me past 3 or because the similar issue is there. All our claim is that they are not
same impugned.
They are not claiming any financial benefit, but the seniority, everything is to be recognized.
But service benefit to be granted.
Yes.
Take note. Same order or a different order?
No, same order.
Same order. Common order.
Yes,
same common order.
Kindly sit down. Petitioner are knocking at the doors of High Court for assailing common order dated. Sit down and say.
26/3/2009. page 55.
Whereby, 26/3/2009, whereby their OA original application OA numbers so and so, just look into, having been favored, the following relief has been accorded by the Orissa Administrative Tribunal. Write down that operative portion of the order. Next paragraph. Learned counsel, Mr. So-and-so, appearing for the petitioners, vehemently submits that once the tribunal was convinced that the petitioners gained entry to public service in a normative way, that is, normative way, there is no justification for denying the benefit of regular service for the period preceding their approaching the tribunal. First off, he points out that the petitioners had staked their claim for appointment pursuant to the advertisement dated 26/10/1998 for the post of junior assistant. Seven, the selection process they underwent only thereafter they have been issued appointment orders. First, learned counsel AGA, Mr. Panda, appearing for the OPs, opposes the petitions with equal vehemence, contending that the appointment of the petitioners itself was not sustainable. During the relevant period, the financial austerity measures were in obtainment. Whatever relief the tribunal has already accorded to the petitioners is more than what they are entitled to. The tribunal has worked out the balance between competing interests and equities. Therefore, interference in this court is uncalled for. Next one. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter as under and for the following reasons. The tribunal at internal page 10 of its impugned order has observed.
No, my lord, 11. Para 6.
Para 6 page.
11.
No, 10 also. An issue has been raised as to
10.
10 is the reproduction of
10 is the
reproduction
reproduction of the secretary's that note. That special secretary, finance. It starts from the page 10.
Para 6.
Para 6 is the tribunal's observation. And
at para 6, the tribunal. At paras 5 and 6 it is.
5, they have quoted the
our government's.
Yes.
Correct. But paragraph 5 and 6.
5 and 6.
has observed as under. Next paragraph. When the tribunal found the stand of the department to be defective, it could not have denied full relief to the petitioners with effect from the date of their entry into service. First of all, be that as it may, years having rolled, some equities have to be worked out for the government also, as rightly contended by learned counsel AGA, learned AGA. First of all, no prejudice should be caused to the OPs if notional benefit of service is accorded to the petitioners without burdening the state with financial obligation. First of all, the tribunal has not accorded any reason as to why the benefit should be from the date of its order. First of all, there are no extraordinary circumstances for fixing the cutoff date like that. First one. Next one. In the above circumstances, these petitions succeed in part. The petitioners shall be entitled to notional benefit of service with effect from respective dates of their entry. That is appointment. Isn't appointment. First off. However, they shall not be entitled to any financial benefits for the said period. Yes.
Seniority, everything.
It is made clear that except financial benefits, all other will be available, including seniority and the longevity of service. Okay.
I'm grateful.
Okay. No question. Item 22. Yes. 6 matter. Tribunal 2026 we are deciding. Yes.
Okay, please, Manoj.
Yeah.
Please, Manoj. Through this writ application, Manoj, we have called upon the legality of promotion of opposite party number 4.
And challenging promotion of OP4.
Yes, and Manoj,
promotion to what post?
Manoj, to the post of a trained graduate teacher. But before that, Manoj, OP4 notice vis-a-vis OP4, Manoj, is sufficient.
That is sufficient.
Yes, Manoj. This Manoj's order that is sufficient. There, he is not being represented, Manoj.
Promoted as a?
As a trained graduate teacher, OP4, which in our claim.
TGT,
yes,
graduate
teacher. Yes, Manoj.
When it was promoted?
He was promoted in the year 2010.
Date you don't have?
Yes, Manoj. Yes, Manoj.
DPC was on 23/12/2009.
Yes, Manoj. The date of promotion.
Date of promotion is
11th of August 2010, Manoj. That's at page 50, Manoj, of the writ application.
11/8. Who are you?
My lords, I'm right to answering my lord's question, my lords. Before that, one more relevant date, my lords. 11th of August is the date of promotion, my lords. And the purported DP is of 23rd of December 2009.
DP was 23/12/2009.
Yes, my lords.
DPC.
Yes, my lords. But my specific case is that until this DPC, I have been all throughout a senior candidate than the opposite party number 4. Now, my lords, all these posts until the trained graduate teacher are in the cadre of junior grade under the tribal educational rules.
Tribal educational rules?
Yes, my lords, 1993.
They are under the 69 Act.
But SC/ST department, the rules is 1993, my lords. It's a direct enactment from 309 Constitution.
Proviso to 309.
Yes, my lords.
You gained entry when?
In the year 1992, my lords. That is, my lords. My lords would find that at page 27 to the writ application.
Date of the.
Yes, my lords. 1st of December 1994. In that same office order, my lords, if I may.
When OP4 gained entry?
Same date, my lords. Same
but
date.
You were above in the select list.
Yes, my lords. I'm just assisting this court. I was at serial number 2 in that office orders appearing in page 24. The opposite party number 4 was at serial number 6, my lords. That was at the entry post of matric city teacher. Now, my lords, at page 31, the DPC happens for the next promotional post, which is the post of Sevak. Yes, all these are, my lords, in the junior grade. Now, my lords, when the DPC to the next promotional post happened, my lords, at page 31, my lords, both I and the opposite party number 4 were promoted. I stood at
same day.
Yes.
That promotion to Sevak was when?
Yes, my lords, office order dated 30th of December 2008.
Huh? 30th of
December 2008.
Both.
Yes, my lords, in that office order, the petitioner stood at serial number 16 and the opposite party number 4 stood at serial number 20. Both are appearing at page 31, Annex 3. Sorry, Annex 1, my lords. I'm so sorry.
You were 16?
He was 20th, 20.
Yeah.
My lords, for the
next promotion.
Yes, my lords, for the next promotional post, what is
TGT?
Yes. What is relevant is acquiring of bachelor's in educational qualification, B.Ed qualification. Yes.
You acquired B.Ed when?
My lords, admittedly, I acquired later on. My B.Ed qualification has come on 1st of March 2010.
1/3/2010.
Yes, my lords. And the B.Ed qualification of opposite party number 4, my lords, admittedly in the year 1992.
1992.
Yes, my lords. My lords, for the promotion to the post of TGT, a gradation list was published in the year August of 2011.
Gradation list of Sevaks.
Yes, my lords. All eligible candidates in the year 2011 for the post of trained graduate teachers.
That is after you got B.Ed.
Yes, my lords. But I found myself at serial number 3.
This is only eligible candidates for promotion.
Yes.
Or it's the gradation list itself.
It's a gradation list at page 34, my lords.
List of
Sevaks and Sevikas to the post of trained graduate teachers, my lords.
This is not Sevak. This is from Sevak to TGT. Not gradation list. Yes.
Well, if I may assist, my lords, it's a gradation list of all savers and savikas.
All savers,
yes, who are eligible
or not.
Well, who are eligible.
Eligible alone.
To be considered by the DPC.
Then it is not a seniority list.
It is, my lords. It is a seniority list of all eligible savers and savikas.
Non-eligible or left out.
My lords.
So it is not, it's only for those who can stake claim for the higher post.
Yes, because because they would need a requisite qualification, which is a B.Ed degree, for being considered to the post of trained graduate teachers.
This is dated?
Was 30th of August 2011, my lords. In the entire list, OP number 4 is nowhere to be seen, my lords.
OP is absent.
Yes.
Why? He is also a B.Ed.
He is B.Ed, my lords.
B.Ed acquired in 1992.
1992, my lord.
Why he left out?
My lords, that is where the cause of action for filing my dispute arose, my lords. Now, opposite party number 4 was all throughout until 2008 was my junior, has been appointed to the post of trained graduate teacher by the impugn notification of the year, my lords, 2010, sorry, my lords.
No, 11/8/2010.
Yes. Through a DPC, my lords, which was held just
December 2009.
Yes, my lords.
Yeah.
Now, my lords, I have invoked this honorable court's jurisdiction to two things, my lords. First thing, my lords, before promotion to the post of trained graduate teachers, the process of there being a gradation list and a DPC, then appointment was absent, which did not happen in the case of opposite party number 4. That is, my lord, my first leg. Second rung, my lords.
So, repeat.
My lords, for the opposite party number 4 to be promoted to the post of TGT, there should have been a prior DPC and a prior gradation list. That has not happened because the sequence of
prior DPC 23/12/2009.
My lords, that is the impugned DPC, because my specific submission is that when the gradation list came in there 2011
for the first time,
yes, for the consideration for the post of trained graduate teacher,
he was not there.
He was not there. Secondly, my lords, in the DPC, assuming that the DPC is valid, my lords, in the DPC, my lords, I'll humbly take my lords to the contents of DPC, but before that, my lords, in the DPC, against 3 vacant posts, 3 recommendations were made. 3 recommendations culminated to 3 appointments.
Not he.
No. There was a reserved panel list, which I am saying that panel list could not have been made because the rule 1993 does not envisage a panel system. There's a panel list where the OP number 4 name was placed. In the event a future vacancy arises,
then alone he will be.
He will be. To which my humble submission, subject to my lord's consideration, is that there could not have been any panel list for preemptive panel list for future vacancies. Any vacancies should be subsequent to a proper,
independently should be DPC.
Proper gradation list, thereafter a DPC, where there would be a recommendation against the requisite vacancies. That recommendation should culminate to a appointment. That is
how this is viewed. This argument is viewed by the tribunal.
My lords, the tribunal's only finding was that the DPC was rightful DPC, because those 3 recommended and appointed candidates, one of them superannuated, we being in the panel list, the opposite party number 4 being in the panel list, he was automatically elevated. My argument with regard to all these not considered was not considered. I am raising before this honorable court right now. Numbers, I will humbly take my lords to the provisions which I am relying on to bring home my points.
Which point?
It's that this DPC could not have been done. Secondly,
why it could not have been done?
Well, it's
DPC happened.
Yes.
23/12/2009.
Yes.
On 23/12/2009, pursuant to that, 11/8/2010, promotion order has
Yes.
been issued.
Yes, my lords.
What is wrong with that?
My lords, my humble submission is that DPC is vitiated.
Why?
Not conducted with right quorums, my lords. I'm so sorry. Quorum was not right, my lords.
What the quorum required is?
Yes. Now, my lords, I'll just take my lords to the rule.
We have understood.
Oh, I'm sorry, my lords.
We judges decide several such cases.
I'm so sorry.
If you say something, we'll be.
I'm so sorry. I'm so sorry, my lords. Now, my lords, the quorum states that each DPC, my lords, should be chaired by the chairman, the DAF schools, relevant districts, and the DWO.
One second. In your way, what you had challenged?
Same thing, my lords. The DPC.
No, you filed OA which year?
My lords, in 2014, my lords.
2014.
Yes. Now to find the prayer.
Was 2010.
Yes.
Then what is that? Within 1 year, you have to challenge that under Section 21 of the Administrative Tribunals Act, 1985.
That is the limitation.
Limitation.
My lords,
where do you stand?
My lords, to answer that, my lords, question, my lords.
And this issue was not raised before the tribunal. This quorum issue was never before the tribunal.
It was there. It was there.
No.
I'll take that.
I have gone through your pleadings.
I'm holding the tribunal.
Gone through your pleadings. There was no pleading to that.
Show that where
there was no occasion for the tribunal to consider.
Where have you taken up that contention?
He has annexed the entire OA, that application. You should show the pleadings.
Because Apex Court says long-standing promotions, rankings in the seniority list should not be disturbed.
Correct.
They create many problems. They may be wrong. If you want to rectify it, bigger wrong will happen.
Upset the settled position.
Yeah. Settled positions cannot be unsettled.
I bowed in minutes. But I
anyway, you show it.
But that paragraph 6 minutes I have tried.
Read quorum non-juris.
Minutes. That it is appropriate to. It's a long paragraph. I can take 2 minutes.
Sentence. The committee was not. It lacked quorum. The committee was a quorum non-juris.
Yes.
One sentence.
But that is not there.
No, that's what he said.
No, why I made such statement as an officer of the court, it's because it is a part of my submission and the other part is there, my lords.
No, submission should arise from the pleadings. What is not pleaded before the tribunal, that you cannot take up before the High Court, except with the leave of the court, and you should amend your pleadings, then leave will be granted, not otherwise. Offhand, you cannot argue. You can't say that it's a question of law and that will not help you. Whether quorum was juris or non-juris, that we can take up only based upon the pleadings.
It's
not available.
If I don't press that point also, I have other
points. Yes, go to other point.
Now, my lords, the DPC never recommended the name of opposite party number 4. There was a panelist.
What is the ground? See, it happened in 2000.
Yes, in 2009, my lords, the 2009 DPC happened for 3 vacancies.
Correct. But you were before the tribunal in 2014.
40. Yes.
What's the explanation for 40?
My lords, I have to candidly concede to my lord's query, my lords. But the thing that I have not written, my lords, I cannot improve that before the honorable court.
That's what. Then you will not interfere. Because Apex Court said that. Latest judgment, 2024 live law.
That's the only my lord's point of endeavor before this honorable court is that because we have travelled through the tribunal to this honorable court.
You should not have travelled at all, even to the tribunal. You are arguing very well. We heard your case is another thing. We'll appreciate. We'll say a word or two about your performance. But law is, read section 21.
That's a point where I have to fairly concede, my lords. I cannot improve thereafter, my lords.
Why his candidature was not considered?
Because he obtained the degree, the trained graduate degree in 2010 and the other one is 1992. Only that premises only.
The date promotion of the other candidate happened, you were not eligible also.
I was not eligible, but that is not my case.
Eligible, cannot challenge.
Yes. No, my lords, if I can humbly try to endeavor, my lords, he was not even in the zone of recommendation, my lords.
How you are concerned with that?
Because, my lords, now all throughout, my lords.
No. In fact, Ramajais has dedicated one chapter on that. Since I had the privilege of working with our great judge, Honorable Justice Ramajais, I'm telling that. In books on service law, they are like the ice cream, if not hotcakes. So beautifully he has said, a person who is not eligible to the post, he cannot challenge somebody's appointment to that post. First principles of service law. You were not even in the zone of consideration because you did not have the eligibility.
Obliged, my lords, obliged, my lords. But my lords, there has to be a gradation list, my lords.
But you are
subsidiary.
You want to say that you had no eligibility.
Right, my lords, right, my lords.
Nothing. Any other point you have?
No, my lords. These are a couple of points for my lords' consideration, my lords.
Kindly be said, but you argued very well. And you are very fair also. You will gain some points by your fairness in the next matter.
We also appreciate his submission.
No, you are very articulate.
Very, very articulate, very articulate.
Any judge not coming from service law would have been swayed away by his.
Yes, definitely.
Petitioner is knocking at the doors of the court for assailing Orissa Administrative Tribunal's order dated 27/10/2016, whereby his OA number 1544 of 2014 has been negative. First, in the said OA, the petitioner's prayer was for upsetting the promotion granted to OP number 4 and to consider his case for promotion. Correct? Yes. Promotion. First, next paragraph. Learned counsel appearing for the petitioner very effectively and articulately sought invalidation of the impugned order on the following grounds. Number 1. 2.1. The OP number 4 was promoted as a TGT with effect from 11/8/2010 pursuant to the recommendation of EPC dated 23/12/2009. That the promotion could not have been granted in as much as the EPC suffered from CORAM non-juris. First, he tells us that the rules, that the extant rules prescribe who should head the DPC, and that official did not head it. First, number 2, 2.2. The petitioner and OP number 4 gained entry to service in on the same day, that is 1/12/1994. Petitioner figured at serial number 4, serial number 2, whereas OP number 4 figured at serial number 6 in the select list. It is.
Office order, it's termed as office order.
In the select list published in the order dated
my lords, 1st of December 1994.
1/12/1994. First time. Subsequently, both they were promoted as sevaks with effect from 30/12/2008, and their gradation was serial number 16 and serial number 20 respectively. That being the position, the promotion to the next cadre, that is TGT, could not have been given to the OP number 4 and ought to have been given to the petitioner. These are the 3 points which are.
Yes, yes.
Right. Serial number 3. Learned AGA appearing for the official OPs with equal elements resist the petition, contending that the OA itself was not maintainable in as much as the challenged promotion of OP4 as TGT happened in August 2010 pursuant to DPC recommendation of December 2009, whereas the petition was filed in 2014. There being 1 year limitation prescribed under Section 21 of the Administrative Tribunals Act 1985. First, he also tells that petitioner secured PED only on 1/3/2010 and therefore he was not eligible to stake his claim for promotion as TGT when that promotion was accorded to OP number 4. Lastly, he points out that the ground of quorum non juris was not taken before the tribunal and that it is only of a recent invention. Next person, having heard the counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the submission of learned AGA. First off, admittedly, both the petitioner and OP number 4 were appointed on 1/12/1994. Petitioner was a senior to OP number 4. Is true. They were promoted as a sevaks on 30/12/2008. Petitioner was at serial number 16 and OP number 4 was at serial number 20 is also true. First one. However, when OP number 4 was recommended by the DPC dated 23/12/2009 and promoted as TGT on 11/8/2010, petitioner did not possess a PED, which is a precondition for staking claim for promotion. First off, without that qualification, petitioner was not in the zone of consideration at all. First off, Mr. Panda is right in telling that a person who is not or who could not be in the zone of consideration cannot challenge appointment of another candidate by promotion or otherwise, when that candidate had the said qualification. First off. Next point. Learned AG is also right in pointing out that the petitioner had approached the OAT only in 2014 when promotion of OP number 6 was in 2010. 2010. First, the ordinarily Section 21 of the 1985 Act prescribes a period of 1 year and at more plus 6 months by way of limitation period. First amendment. There is no explanation whatsoever as to the long delay proved in the matter. First amendment. Settled things should not be unsettled. Is the rule subject to several exceptions. And the argued case of the petitioner does not fit into such exceptions. First off.
He has not arrayed the other persons who are promoted because in their absence this cannot be decided.
We also notice that for other person, no, may not be necessary because OP4 is the
OP4 is there, but others are also appointed.
Correct. Their appointment is not challenging.
Affected is not their appointment will be unsettled.
No, that will not happen. Lastly, learned AG is also right in telling us that the petitioner had not pleaded as to the ground of non-juris, quorum non-juris. Quorum non-juris. And therefore, this court cannot permit the petitioner to take up such a contention in the fitness of things. Such a contention is even otherwise not available to the petitioner who was not eligible to be considered for promotion as on 23/12/2009 when the DPC met. In the above circumstances, this petition being devoid of merits is liable to be dismissed and accordingly it is, what's having been made, easy. Registry to send a copy of this order to OP number 4 by speed post immediately.
Grateful.
Yeah.
We are grateful.
You argued very well. Yes. One thing I should tell you, you read Halkiwala's biography. Most of the famous cases which he has argued, all he has lost. You may become another Halki. But don't lose other cases. Yes. Next.
Utility item 2. This is a simple matter of appointment of an Hon'Ble worker. But the petitioner was appointed as Hon'Ble worker in 10/8/2016, being the most meritorious candidate. 10/8/2016. Then one
Anganwadi worker.
My lord. Then one ineligible candidate who could not succeed filed an appeal before the ADM. And that appeal, my lord, allowed in setting aside my appointment, my engagement on 23/8/2018.
Which respondent?
My lord, opposite party number 4. Number 4.
OP4 challenged your appointment.
Yes. Engagement, and that was been set aside my engagement. And then I have approached this honorable court.
1 second. Challenge in appeal it is?
Appeal. My lord, ADM.
ADM.
My lord.
ADM means?
Additional district magistrate.
Challenged.
Sub-collector is the chairman.
ADM made order dated?
My lord, ADM passed the order on 23/8/2018. Everything in August, 23/8/2018.
All right. Appellant married to the village of Jalanga.
Well, that's I have mentioned this because
local
No, I'm married to the new village, so I need a residential certificate. That is not in the advertisement. Only 2 points have to be considered. Advertisement said, my lord, that is in English translation I have given, and other one I am giving, your lordship, that one must be hailed from that area. That is not there. No resident certificate has to be submitted.
Yes.
My lord, that my point is that they have challenged on 2 grounds my engagement, that one must be from that area, that is the advertisement, annexure 1.
No, it is not. From the where the center situates.
Yes.
He must be from that area.
Yes, I am from that
From
area.
that locality.
Local area of the center.
Center. Yes, I am from that area because of my marriage. I have applied, and when I got the residential certificate on date of verification, it was there. That is the date of verification by the sub-collector, my lord. That is on the date
36, 2016.
My lord, that is on that date I have produced my original certificate. So the honorable single bench has decided, my lord, that why that is not on the 16th day. The 16th day is 7/7/2016 as per the advertisement. 7/7/2016. But that was a holiday.
Therefore, next day.
Therefore, he placed the file, CDPO, Child Development Project Officer, placed the file before the sub-collector.
Next day.
On 36, much earlier than the last date of submission of application. Because 7/7 day is a holiday. So, sub-collector put it on the 12/7/2016 for verification. 1 working day, my lord, 11/7/2016 is skipped. Only 1 working day. And
instead of that 12/7.
12/7. That is by the sub-collector. No malafide was alleged. Nothing. Only on sub-collector order, that is on 12/7/2016, and I have produced on that day my residential certificate. They are saying you have that guideline. These are all resolution. Anganwadi worker by throughout only resolutions of the government. There is no statutory rule. They are saying the plea of the opposite party ADM is that rule is rule. So on 16th day, if 11/7/2016 is a working day, then if that has been skipped, so this whole selection is set aside. And I lost job, my lord, just now in September during pendency of this appeal. But the interesting fact is who has filed the appeal. My learned friend is appearing. He has not appointed. She has not appointed. Engaged. Another person from the select list got appointment recently. If the selection was bad, how can the other one could appointed? Well, be that as it may, your lordship may draw your lordship's kind attention to page 65, the impugned lordship before your lordship. Only 2 dates. My lord, that from the facts narrated, it is evident that the petitioner had not submitted her residence certificate along with her application. My lord, that was not required. The last date for submission of...
Why do you say it is not required?
Because it is, one must hails from that. You are not have to deposit the residential certificate.
Okay, no,
that's the English translation.
They will assert whether you hail from that area or not.
There is objection is there. That a 10 days objection period is there. I have applied with the Sarpanch undertaking that yes, I am married there and I will produce that on the date of verification. But advertisement says this has to be deposited, this has to be submitted, this has to be submitted. In the place of this, they have submitted one must hail from this area to this area.
Submission is not there.
Submission is not there. But they are saying, then I have produced, my lord, on the date of verification.
For other things, they have required submission.
Submission. That you must be certificate, you must be matriculate, you must be this, whatever the requirement. I have given that in English translation, my lord.
In other words, what you say is,
my lord,
even without production of such a certificate, my application was in order.
Yes.
If they had any doubt as to my locality, they will ask me, and then I will.
Then, my lord, exactly, that is my... Then, my lord, on that ground, then the learned honorable, it is not disputed that 6/7/2016 and 7/7/2016 were holidays. Therefore, the last date of receipt of application would be automatically extended to the next working day, that is 8/7/2016. The guideline dated 2/5/2007 provides that the date of scrutiny would be the 16th day from the date of application. In the instant case, the date being originally 7/7/2006.
When you were issued that certificate?
But I am issued on 11/7/2016. On date of verification, I am having the certificate. On the date of verification of original documents, I produced my certificate. So only one date skipped by the sub-collector, that is the working day of 11/7/2016. It is my last line I am reading. It is not disputed that the next working day was 11/7/2016. The petitioner submitted an undertaking. So on 11/7/2016, it was only one working day skipped by the selection committee chairman. It is not my request. It is the official order. My lord, kindly see that I have added.
How learned single judge treated your contention that there is no requirement of producing any certificate?
That is gone against me.
That's what I'm asking you. What is the reason why he says? Because there is no such requirement in the notification.
In the advertisement, my lord. But that is the para 11 of the impugned order that I am reading. The last date of
no, that we have read.
My lord. And therefore,
why one day was skipped is the reason.
That is the only reason that my appointment set aside and they have terminated me. And my lord and friend's client has not been appointed. Somebody else has appointed.
If I may ask, there are two contentions also. Whether the residence certificate was needed to be filed along with the application. Second is whether
when the marriage happened.
Marriage in May, advertisement in June.
Marriage is a must or may.
Well, that I have prepared a small date chart I have given.
Have you mentioned your marriage date?
Yes, my lord. That's important to this. 4/5/2016.
4/5/16.
My lord.
16. And you had applied for certificate when?
My lord, after the advertisement.
The advertisement was on 22/6/2016, a month after your marriage.
Before the honeymoon period was over.
Exactly, that is the.
The government wants that you should have skipped off honeymoon period and applied for this copy.
My lord.
Yes, brother.
Yes.
What is it?
So there's two questions.
Just show me the advertisement.
Annexure 1, my lord. That English translation I have given me. And that is also there in the file.
Who are you? You had filed the appeal.
I had filed the appeal before the ADM. I was one of the parties, candidates.
Candidates in the fray?
Was not selected earlier.
You were not selected?
No. She was selected. Then I went in appeal before the ADM.
Suppose if her appointment is set aside, whether you would have gained the appointment?
I was supposed to be, but now someone else has been appointed, I was told. After the judgment of the signature.
Correct, but what is your locus?
I was one of the candidates. If her candidature goes, I should have been.
But that has not happened.
That has not happened.
Then where is your locus?
I will have to take instructions on that.
No, not something. Law. Anyway, if you were to be there, I would have appreciated that. That would upset your apple cart, and therefore you will have a cause of action.
So by virtue of an IA filed by my learned friend, I came to know that somebody else has been appointed. So I need to take instruction why I was not.
Premises unless you challenge that we will ascertain it from government and we will proceed.
Yes, sir.
1 second. Where is that condition? Applicant must be permanent resident. 18 years.
Clause 1.
The applicant shall submit the proof of caste certificate. If the applicant is parentless, the certificate. For everything, certificate is sought for. Physically disabled, then a photograph must be submitted. Divorcee.
Only clause 1, there was no certificate sought for.
With the copy of certificate, all documents shall be attested by one gazetted officer. Applicants are to submit 2 passport size photographs. Self-addressed envelope copy is so and so. Candidate will be selected. So and so.
Your Lordship, this advertisement is governed by the guidelines for Anganwadi workers.
Yes.
Guideline of 2/5/2007.
Yes.
It lays down the procedure. If I may read.
Where is the requirement of producing the marriage certificate? Or residential.
It is there in the procedure.
Yeah, very.
If I may read it. In case of engaging Anganwadi worker for casual vacancy or for new Anganwadi centers, notification regarding the Anganwadi center where the Anganwadi worker is going to be engaged will be put up simultaneously in the village in concert Gram Panchayat and Panchayat Samiti. 15 days time will be given to the candidates to apply to the CDPO along with the documents in support of nativity, educational qualification, caste, and any other. So documents with support of nativity is required. This is the first contention, that residence certificate.
What is that rule?
That is the Anganwadi workers rule, the guidelines.
Guidelines.
And is anyway, there was a resolution
on this.
With
Page 29.
You should ask him to the report officer.
Page 31.
Then we will have some STC here instead of you.
I am reading the procedure B. Towards the end of the page.
Whether these rules are published in the Gazette?
No, this is all resolutions. And every year it changes with the government.
Can I read it again, Worship?
No question. Unless this is published, how she will know?
Yes.
How candidates will know?
But then the appointment are governed by all these resolutions time and again with changes.
No, we are asking you. How a candidate, Anganwadi candidate, she does not come from Oxford.
I understand that.
She is from rural area, married to particular area. Is it true? How she will know that these are the rules promulgated to the world at large, and therefore everybody is supposed to know? That you can claim, provided they are gazetted.
I understand.
Advertisement should disclose it. No, advertisement does not fit. Advertisement says what should be produced, what should not be produced.
Your Lordship is correct that, my Lord. 7 days time will be given for filing of objection. D.
Which is that judgment of the apex court. Unless rules are published, there are no rules.
Notice board 7 days time will be given for filing of objection, if any, by the community on the issue of nativity, educational qualification, and caste certificate. There is a provision that my Lord, D, that procedure, clause D, page 32, first one. So if somebody is not from that area and she apply, then that public can file an objection. The 7 days time.
It is for the people to file objection.
Yes.
That's why they have not demanded.
No, what your learned friend says is, there is a resolution pursuant to which all these things are done.
Exactly.
Therefore, the candidate is supposed to know this is
that's it.
View.
Also, Your Lordship, in support of this contention, I may place a judgment of a division bench of dissent.
Whether this aspect is considered?
Yes. Exactly.
I don't think that whether unless it is published, that aspect.
No, with regard to whether residence certificate is required to be filed with the application or not.
Harla. Yes. AR 1951 AC. Science. Yes. There was one more judgment. Harishankar Bagla versus State of MP. Justice Matthews judgment.
If I may bring Your Lordship to para 6. May I read it, Your Lordship?
Para 6.
Yes.
It is undisputed factor for filing the purpose of very essential as condition one of the advertisement. It was there in the advertisement itself.
Yes.
But here it is not there.
Yeah, that's the point.
In para 6, it proceeds on that premise, as you argued rightly, that the advertisement itself say, produce the residential certificate.
No, the advertisement in that also, Annexure 1 clearly states that the applicant should be a resident, should be a permanent resident of the concerned village. Here also the advertisement says the same thing. 4th line, Your Lordship, towards the end. The production of residence certificate is very essential as condition 1 of the advertisement annexure 1 clearly states that the applicant should be a permanent resident of the concerned village. In this case also, the advertisement clause 1 says exactly the same thing, that the applicant should be a permanent resident of the concerned village or the Anganwadi center.
No, where is that? This is of 2011.
This is of 2011.
11. Where is that? See, rule 1 of the guidelines for selection of production of the retention certificate is essential. Rule itself says that.
Is essential as condition 1 of the advertisement clearly states that the applicant should be a permanent resident.
That permanent resident, we agree.
Yes.
But where is the copy of that, the text of that, which the division bench coordinate been treated? Because these advertisements are issued whenever they want to recruit. So periodically, the text need not be duplicated. Do you have that 2011?
No, Your Worship, I do not have it.
No, anyway, brother, how you will be aggrieved now is we are now on your locus to oppose the petition.
I was taking instruction on that. I was taking
district collector or what?
ADM. ADM. I was taking instruction on that, and I was told I have been appointed now. I am in. After her disengagement, I have been engaged.
Mr. G, whether he is appointed?
No, my lord, I have filed my engagement order.
I have no instruction.
He is not.
Who has,
Other than
no. I have no instruction who has been appointed there.
Sakuntala Balayar Singh appointed, and he happens to be the sister-in-law of the
appointee.
The who has filed the appeal. That is, local MLA is the appointing authority.
Local MLA appoints all these people.
All these things happen because of their.
No. There is a committee. CDPO is there.
Another
it is not that.
Whether the sub-collector can skip one. Whether sub-collector, they are in the village, somebody else appointed, and he is saying that I will
because, see, what all certificates to be produced, they have specifically said.
Yes.
Produce the certificate. Produce the certificate. But this residential certificate, they have not sought for. That does not mean a candidate cannot produce it. He has to produce if asked for.
So here, the candidate of Anganwadi center, village or part, he must be a resident of that place.
Correct.
My lord, to prove that, my lord, he has to prove.
No. Next conditions you read. The proof aspect is reflected in the other conditions.
Yes.
Just education.
Education, caste, other things are there.
There you have said certificate should be produced.
Yes.
The certificate to be produced has not been.
Whether it is true what you said? You are being appointed?
We are engaged. We are engaged. Somebody else was engaged. She has resigned and we have been engaged. Now, as on date, we are in.
Which date you came to be engaged?
Sorry, Your Worship.
Which date you came?
I will have to take instruction.
Please. Number one. Number two, where is the prescription, the promulgation of 1951 Supreme Court? Where is the promulgation?
It has not been here.
Then nothing can be.
Second, Your Worship, if we come to with regard to the deferment of the date.
No, we are not on that.
That is also part.
Question me, what happens if the jurisdictional authority is a matter of indoor management? What control she will have over the...
But again, Your Worship, this resolution says that if the 16th day is a holiday, the next working day, the verification should have been taken place.
On 11th. On 11th. Is it not?
On 11th. No, 8th was a working day.
Correct. No.
8th was.
Last date of submission of application.
Last date of submission was 7th.
7th.
So it is extended automatically to 8/7.
Now that question will not arise because we are holding that these are not published.
Published. If your lordship goes by that, I don't have the.
You are more than fair. Take that. Kindly be seated. Which is that there is one maxim which interpretation of statutes by Maxwell. How that? Expressio unius. Expressio ulterius, expressio unius, exclusio ulterius. When one thing is asked for, but the other thing is not asked for, presumption is the other thing is not asked for. Harishankara Bagla, 55 years. In that it was decided. It was there? That provision? No. The promulgation of the rules is a must. Unless they are published, they have no force of law. Okay. That's the judgment. Our professor was very good. He used to tell us the doctorate from America.
I was appointed on 28th October.
28th October. Take down. Your OP number?
4 in this appeal.
Intra-court appeal.
Intra-court.
These things do not go to tribunal.
No.
No, even otherwise tribunal.
This was before the single judge.
That's one. This intra-court appeal seeks to call in question a learned single judge's order dated 25/4/2025, whereby which respondent you are? Sit down and answer. Fourth respondent's WPC number 17149, correct?
17147.
147 of 2018. Whose petition it was? Your petition?
Yes, my petition. I was working.
Appellant's WPC number 17147 of 2018 having been negative, has been negative. First, in the said petition, the appellant had called in question the order of the appellate authority. Appellate authority dated, can you give the date? 23/2018, entered in AW appeal number 11 of 2016, whereby the engagement of the appellant came to be rescinded. Rescinded on the ground that she had not produced the nativity certificate, residential certificate, nativity stroke residential certificate. Next paragraph. Learned, can you be seated? You can answer by sitting only. Learned counsel appearing for the appellant vehemently argues that the advertisement dated 22/6/2016 did not require production of nativity bar residential certificate, as on the last date of submission of the application, that is 7/7/2016, the who has passed the order? Nativity, first appeal order?
In the ADM, additional district magistrate.
The additional district magistrate had grossly erred in setting aside her client's opponent's
ADM Puri. Additional district magistrate Puri.
Grossly erred in setting aside appellant's engagement, which aspect has not been properly dealt with by the learned single judge. First of all, she further argues that her client had contracted marriage on 4/5/2016 to a gentleman in the village of Delanga. She had applied for the nativity certificate after the advertisement was issued. Advertisement dated on 22/2016. Immediately after obtainment, the same was produced for verification. That was done on 12/7/2016. First time. So, arguing, she seeks allowing of the appeal. First time. Learned counsel appearing for Mr. G. Do you want to say anything?
No, my lord, only I am to support the contentions made in the judgment, my lord. Their lordship says at paragraph 13.
Yeah.
Two things emerge from the above analysis. The petitioner's application was incomplete in the absence of the residence certificate, which as per advertisement ought not to have been considered. Second, the residence certificate belatedly submitted by her was accepted beyond any stipulated date, which is contrary to the guideline. That's what.
Where your advertisement says
advertisement
certificate should be produced on the same date.
My lord, advertisement says that it should be
so and so.
So and so.
In other things also, he should be SC/ST. But it says he should be SC/ST and produce the certificate.
My lord, to come to the conclusion that he has to produce a certificate. On the date of application.
You said that in the notification.
Date of application she has not produced.
Correct, because there is no requirement.
That was the requirement because of the rules that the guideline says. Accordingly, it was not mentioned here. The certificate has to be produced.
Learned AGA makes a submission in justification of the impugned order. So does the learned counsel appearing for OP number, response number 4. First up. They draw attention of the court to the notification dated 2/5/2007, which promulgate the guidelines for Anganwadi workers. In words, the guidelines for Anganwadi
workers.
According to them, these guidelines constitute the law, though they have been issued in exercise of executive power of the state under Article 161 of the Constitution of India, and therefore production of nativity certificate was a sine qua non for staking claim for appointment. Stop engage. First, learned counsel representing respondent number 4 places reliance on a coordinate bench decision in Sakhi Pradhan versus State of Orissa. Not reported there, brother. Any neutral citation is there?
I don't think it's reported. I don't see any citation.
In writ appeal number 394 of 2010, between Sakhi Pradhan versus State of Orissa, disposed of on 13/4/2011 in support of his contention. First one. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we are inclined to grant indulgence in the matter for the following reasons. First, column number 1. There is force in the submission of learned counsel for the appellant that the advertisement dated 22/6/2016 does not require production of the nativity certificate along with the application itself, although it is open to the selecting agencies to seek production at the time of scrutiny, if need be. First off, reasons for this are not far to seek. First off, firstly, wherever production of certificates is made a must, the advertisement itself says about that. For instance, the advertisement requires production of caste certificate where candidate belongs to SC, ST. What if the other semicolon? It also requires production of educational certificates of educational qualification. First one. However, such a requirement is not reflected in the text of the advertisement so far as nativity / residential certificate is concerned. First off, this is a textbook case for application of the maxim expressio unius. You got the book? You have that? Yeah. Est exclusio ulterius. Correct? Correct. Which Maxwell on interpretation of statutes discusses as a term. Just that production there. Next point. The vehement submission of learned AGA and learned counsel appearing for the respondent number 4 that the resolution dated 2/5/2007 prescribing the guidelines requires production of nativity certificate may be true. First off, however, a resolution does not partake the character of law, nor can it be much pressed into as against rural candidates like the appellant when the same has not been published in the official gazette. First, the apex court in Harishankar Bagla versus the judgment. State of MP, AR 1954 SC 465 paragraph. No paragraph number, as observed as under that particular part you just gave that. Next point. The next contention of learned counsel appearing for a private respondent that a coordinate bench of this court in Saki Pradhan has held that the production of nativity certificate along with the application is a must, is true. First off. However, what was the text of advertisement involved in the said case is not forthcoming from the contents of paragraph 6 of the said decision. The said decision that was rendered years ago. First off. Secondly, the very decision at para 6 reads, see, this sentence you have to yes. It hardly needs to be stated that a decision is an authority for the proposition. It lays down in a given fact matrix and not for all that which logically follows from what has been so laid down, said Lord Halsbury in Quinn versus Latham, in 1901, AC 495. First one. Last. Next one. There is one finer aspect to the matter. No, that question will not happen. Because he says in the above circumstances, this appeal, one more point. It is relevant to mention that the appellant had contracted the marriage with a gentleman of village Delanga on 4/5/2016. She had applied for the residential certificate. When did you apply for?
After the notification, my lord. That it was put there.
Nativity certificate post issuance of the notification dated 22/6/2016. 16. Soon after its procurement, she has produced it, and the scrutiny committee had looked into it. First off, only thereafter the engagement order was issued. First off, that being the position, it was not open to the ADM to set aside the engagement order in AW appeal number 11/2016, decided on 23/8/2018. First up, one has to keep in mind that schemes of the kind are also meant for providing employment to the villagers. First one. Job Anganwadi job of Anganwadi worker is not a lucrative employment. First off, more often than not, persons belonging to lower economic strata seek such employments. First off, therefore, on technical grounds of delay in production, an employment given already cannot be cancelled to the detriment of the candidates. First off, an argument to the contrary would place legality above justice. And a welfare state like ours cannot afford to do it. First, in the above circumstances, this appeal succeeds. Impugned order of the elected single judge is set aside. Petitioner appellant's WPC number so and so having been favored, the ADM.
Yes, ADM.
ADM's order dated 23/8/2018 is quashed. As a consequence, the engagement order dated
28/10/2025.
28/10/2025. 25.
My engagement, the last.
No, this
appellant.
Mine 10/8/2016.
2016 is restored. And whatever appointment orders have been issued to others, being list pendants, will not be given effect to. First off, which authority has to issue the continue?
CDB.
The OP number?
Sub-collector.
Respondent number. The official respondents are directed to continue the appellant in service with no back wages. Immediately. Employment immediately in service with no back wages. No costs.
Instead of back wages, my lord, what's the matter? Remuneration.
With no remuneration. With no remuneration. With no back wages, stroke remuneration.